And welcome to our second webinar of the young members of the German National Group of AIPPI. Our topic today is IP perspectives on artificial intelligence. And in that regard, we're taking a step back and exploring a very new topic compared to last year, which was rather focused on the UPC. So as you can see, it's a young members webinar. So even though we're doing this as part of the German National Group of AIPPI, we're also in the context of the International Young Members Movement and, so to speak, have a very young approach to these matters. And all of our speakers today will also be young members, mostly from the German group of AIPPI. In terms of topics, we are now looking at artificial intelligence in particular, and we are closing in on that topic via 3 different panels, which you will see in a second. So panel 1 will give a technical and patenting perspective on AI. Panel 2 will provide a rather regulatory approach, so IP-specific risks of AI, current important laws also on the EU level, trade secrets and other implications. And panel 3 will then take a close look at AI infringement and the enforcement of patent rights on AI inventions in particular. Maybe as a short introduction for myself, I'm Niclas Gajeck. I'm a patent litigator from Munich, and I will do most of the moderation for this day. And for now, we will have a very short welcome address from our president of the German National Group AIPPI, Carsten Königer. Carsten, thank you for coming and very happy to have you.
Well, thank you, Niclas. Thank you very much. Once I was a young member too, that's some years ago, but you can see my gray hair, and that is not AI generated, but it's real. I don't know if you can check, but it's real. And of course, this is just a greeting from the old members to you. I cannot express how happy we are about this development and about your activities. When I was a young member, there was no such thing like a webinar, of course, that's the first thing. But more important, we were not never asked to speak anywhere or to give any comments. And this has changed completely, and we are very happy about it. We think that although you are called young members, of course, we are aware that you are not only highly qualified, but also very experienced lawyers and practitioners. So, of course, it's very valuable for us to hear your perspective and about your research. As always, we can only motivate you to take part in our meetings, to work for our study questions, and to apply for seats in committees. There are still vacancies in committees, and we would be very happy to have young members in such committees. So I think this is enough from me. I wish you a very successful meeting, and I'm very, much looking forward to learn what you can tell us today. So have a very good day. Thank you. Niclas.
Thank you so much, Carsten. So, and this gives us an opportunity to maybe look at the housekeeping slide and go over the general technical issues that we will have to keep in mind for the webinar as a whole. So webinar will be recorded, made available on the AIPPI YouTube channel. The slides will be available upon request at the email that you're seeing right now. And you can ask questions anytime during the webinar via the Q&A function, which you will see below. And for any comments, exchange of ideas, similar, please use the chat box. I think we are still doing the certificate for German IP specialists, so for Fachanwälte für gewerblichen Rechtsschutz in particular. If you need a confirmation in that regard, please let us know. But you will also have to maintain attendance throughout the webinar, of course, to get the full hours. If you have any technical problems, please send a message via the chat box to AIPPI events. And there will also be a brief survey after the webinar. And yes, as always, we'll appreciate any feedback. With that in mind, let's give the first panel a chance. And I'm happy to introduce our speakers for that. So as stated before, we will now look at the technical and patenting perspective on AI. And for that, I'm very, very pleased to be able to introduce to you our speakers, Markus Eustermann, who is a German and European patent attorney, works as an associated partner at the law firm DTS Patent- und Rechtsanwälte in Munich. And he has a technical background in mechanical engineering from his University of Applied Sciences studies in Ulm and at the Technical University in Munich. And he's not only active in prosecution, but also in litigation in front of courts and patent offices since the start of his career in 2018. And he also gives IP lectures at his alma mater in Ulm for master students in medical engineering. And in that regard, he's a very, very perfect choice for this first panel in particular, where we're also talking about patenting and similar matters. And as his co-speaker, we will have Hendrik Meier, who works as a research assistant at Leibniz University at the chair of Professor Dornes, private law, intellectual property law, and is also an assistant to the editors of Core Patent. And his research focuses on intellectual property law, especially patent and copyrights. And the working title of his thesis is Scope of the Prior Use Right in Patent Law. And some of you may recall AIPPI's recent study question on prior use. And yeah, we're very happy to have Hendrik, have a specialist in all of these matters, work on that with us as well. As honorary mentions, unfortunately, we won't be able to be there today. We also had Rolf Lechner work with us on the presentation. He's a qualified European patent attorney who's been working in IP law since 2019 with a special focus on mechanical engineering. Unfortunately, he won't be able to join us, but he contributed a lot for the presentation, and that's at least worth the honorable mentions. So with that, I'm happy to hand it over to Markus and Hendrik for the presentation.
Well, good morning, everyone. And Niclas, thank you for your very kind introduction. And also, Carsten, thank you for your introduction in the beginning. I'm quite honored to actually give the first speech of today's webinar. The next slide, please. Yeah. Well, unfortunately, I will probably have to start with one of the worst slides in this panel, as there's just too much text on this side. But why did I choose this design anyway? The answer is I want to give you a perspective in the legal debate around the technical issues, as I'm having a background in law and not engineering. Well, so my first starting point was to look for definitions concerning AI. Well, I chose the one from the AI Act in Article 3, Section 3, number 63, which is the general purpose AI model. Why did I choose this one and not, for example, the one in number 1, which is maybe even more closer when starting to read the AI Act? Well, the answer is it defines the AI systems. Well, to understand why there is a difference in wording, we have to understand that the AI Act has an underlying understanding of two different things, which is the AI system and the AI model, which are separately seen. In general, the idea is that the model is basically the smaller part, the specific algorithm, while the system is an integration of multiple models, or, for example, an integrated AI model in an overall system. Okay, so let me start with this very definition that will kind of lead us through this first part of the panel. Generally speaking, it says general purpose AI means an AI model, including where such an AI model is trained with a large amount of data, which is kind of the focus for our panel, large language model and generative AI that use or utilize a large amount of data. Continuing with the definition, using self-supervision at scale that displays significant generality and is capable of completely competently performing a wide range of distinct tasks. Well, generally, this is the idea that will keep us going for the legal debate. Next slide, please. Now, going back from this very specific definition and to the general idea of AI. Well, to have a starting point, technicians are quite fascinated by the human brain and the wide range of tasks we are able to fulfill, while machines may not be able to do the same. That's why we kind of do research to figure out this ability and in order to transfer it on machines. For that, an activation function has developed that is based or triggered by weights, which are learned through the AI training, which will come in the following section. Okay, next slide, please. Okay, well, generally, each activation site utilizes neurons, which then trigger and forward information. Multiple neurons put together are called a neural network. That's well, basically forwarding the information through an input layer, starting in an input layer, going through multiple hidden layers, which is what makes it a deep neural network, and then coming to the output layer, creating the actual output. For example, a generated image, a text that can be formed, or for example, translation. Okay, this is just so much to the general structure or structural idea. As you can see, very similar to the idea of the brain having multiple neurons interact with each other. Next slide, please. Okay, so now let me come to the very process that we are focusing on. I tried to put it into 3 different steps. So the first one is the collection and preparation of data, meaning the actual source that we kind of fuel our AI model with. The second one is the actual training, where our data is analyzed and put into parameters in order to feed these weights. And last but not least, the actual usage of the AI. Each one of them will be a theme of our first part of this panel. Okay, next slide, please. Okay, so the first question that we start with is actually, where do we get this data? We need a lot of it, and well, the answer is quite obvious, the internet. The internet is basically a huge database for human interaction, human invention, and yeah, human data. This data is very much needed in order to solve problems. But at the same time, the amount of data is so big that we cannot handle it with simple, well, human workforce. That's why we utilize web crawlers in order to collect this data. These web crawlers simulate user interaction with websites to copy this data and then transfer it to the developer. An easier way to gain this or get training data is by asking libraries such as Lion that pre-prepare such data sets and provide URLs, for example, to access this data. What Lion, specifically Lion does, for example, is collecting picture data through means of web crawlers, and then run it through a program of picture analysis, where they check if the label, or where they create a label for a picture, check if this one fits to the actual picture, and then again delete the picture. But what they keep is the label and also the URL. And these are provided then for example, research institution in order to train their own models based on this data. This was also a topic of the District Court of Hamburg in a recent court case, which will come up quite a few times, I guess. Okay, next slide, please. Okay, now, when it comes to data, there's just generally the idea that as much data as possible is always better. There's the saying garbage in, garbage out, or as on this illustration, garbage in, data out. General idea there is that if you do not have the quality of data, you will only receive a bad model. For that, we need quite an amount of data, but it also has to be qualitatively high standard. It has to be representative for the specific task at hand. So for example, if you want to create a model that can distinguish dogs from cats or different breeds of dogs, you will need to train it based on data that include dogs. Well, pretty forward there. But not always does the content matter. A very fine example for that is the smart reply option in Gmail. Google tried to offer users the option to automatically generate responses by emails by training the very model on these email responses. Problem was that just training them on emails created authentic answers, responses that did not look human. So what they did instead was they had to train it on their library, as Google digitized quite a amount of books, and especially their Romans library. Interestingly, the content itself, as Romans do not quite matter for emails in general, was still used, but actually that is what made the responses for emails even more human, making them authentic, showing that technically not even the semantic data that we're talking about is necessarily relevant, but sometimes the syntactic data, basically copying the human interaction or copying the human syntax. Next slide, please. Thank you. So now, once we've gathered our huge amount of data, the actual question is, what shall we do with it? Well, generally the answer is we have to prepare it in some way so that the model can actually analyze it. For that, since the model itself is not actually smart, we have to kind of train it to recognize pictures, for example. We need to do some explanation. We can do it, for example, by label, showing them a picture of a dog, labeling it dog so that the AI model can recognize it. Well, labeling part is quite tedious since the data sets are simply so big that no human can by themselves label everything. That's why, for example, Google did quite the smart move where they utilized the capture feature, where you basically ask if you're human when you're interacting with a web page, to ask the users of these web pages to click on specific pictures, creating labels with the content that was then utilized for the actual training of AI. Now, another thing you might want to do is, specifically looking at picture generation or training with pictures, you want to have a unified format, for example, so that the AI model can actually compare these specific pictures. Another thing you might want to add is noise, depending on the specific model. That will also be a topic at a later point. But generally, for a diffusion model, the idea is that those models can translate noise into actual pictures. For that, next slide, please. For that, we add pixels to different pictures, which make it hard to recognize the picture, which then has to be recreated by the model. So starting from the left side, we have the actual butterfly scene and visible, becoming more and more noisy until the model is able to actually create a picture from the right side. This is also what makes it able to create things from a simple prompt. Another option is to mask text, like blacking out specific parts of a sentence, which then have to be filled out by AI. Okay, next slide, please. Thank you. Well, when it comes to data sampling, another issue that arises is the issue of bias. This will lead us a little bit astray of the IP discussion, but still is quite relevant when training your model. General question is what contents should be included in AI training data sets? Well, the answer is it has to be representative, as I already mentioned, but that also means that we have to look at human biases in society, for example, meaning that if we train a model, somebody speaking, to recognize huskies, if we put them in always in a snowy environment, a model might not be able to recognize it as a husky if it is not in a snowy environment. That was actually a very simple problem, but still led to the confusion for this machine. For that, we need varying pictures so that the AI model can see. This issue seems quite small when you're just looking at huskies, but it can become quite big if you're, for example, thinking about a prediction of criminal liability rate or such things, i.e. the system that is utilized in the US called Compass, which predicts if a person will fall back to criminality or not. If this very system is trained on biased data, for example, biased against specific minorities or similar things, they might get bad results for the specific group, thus creating a discriminatory system. The influences of bias can come in multiple ways. For example, just very much in this already in the collection of sampling data, but also during the processing or labeling. So if we do mistakes at this point, it might create confusion. Okay, now going back to the IP part. Next slide, please. Here. Well, generally, once we have our data, the question is, what is going to happen then? Well, the answer is we will be training and analyzing this data through the model. And this is actually what enables the model to generalize. In this case, meaning that it is able to deal with data that was not included in the original training data set. Well, during this training, parameters that acts as weight are developed, and these activate the neurons of our AI model. Well, and exactly what method we use depends highly on the desired task. So, for example, if we want to generate things, we might want to use a different, use them for labeling things. And it also depends highly on the available data. Next slide, please. Yeah. What I try to do with this slide is break down these learning method as simple as possible, focusing basically on two parts, on the training data and the defined outcome. Well, when looking at supervised learning, we have a training data set that's clearly set, and we have a quite defined outcome. So we want, for example, that the AI model is able to recognize a dog as a dog, and we know that this very label exists. While in unsupervised learning, we do have, so this might be confusing there, but anyway, we have a data set that is based on raw data, meaning it is not labeled, and the AI model then has no defined or specific outcome except a specific task, which is, for example, to cluster certain elements in this raw data set, or to recognize patterns in these systems. A third type could be mentioned as the reinforcement learning, where there's technically no training data, but a defined outcome, for example. And this is very relevant for robotics. For example, when a robot is supposed to open a door by utilizing a key, picking it up, putting it in the keyhole and turning, and then using the handle to open the door, has to learn by some sort of way. And this is done through rewards and punishments in the system itself. And generally, this method can cause harm to the actual equipment. For example, when training a robot to climb upstairs. That's why there are methods in development that can work virtually, utilizing the, for example, Sora that can simply create or generate actual videos. And so creating a virtual environment for the actual system to train in is the idea that kind of could come into the future or lead us into the future. Next part, next slide, please. Okay, thank you. Now, another issue that can arise is the model itself. Highly depending on the capacity of the AI, we might create an unfitting model when looking at the training data set. So, for example, if the capacity, meaning the amount of layers and neurons in that system, which is determined by the hyperparameters, if this very capacity is too low for the actual training data set, we will see a high error rate on the training set itself, but also on unseen data, simply because it is not able to fulfill its task properly. On the other hand, having a model that has a quite too high capacity is also problematic, as what might happen is that it kind of metaphorically learns the data set by heart, which can cause it to even reproduce things such as noise. And it also will fit too closely to the training data set, creating questions of copyright issues. In that sense, the ability to generalize in this way is very low. How to change this issue? The answer is you can change the hyperparameters and adapt the capacity, but this will force you to do a new training run. Next slide, please. Okay, another issue that can come with the training is the memorization, which will be also a huge part in the second panel. Memorization generally means that an AI model actually is able to verbatim reproduce words that are in the training data set, asking the question if this is a reproduction or a copyright. Well, generally, it is estimated that an amount of 0.1% to 10% of this data is actually memorized. Well, giving us the hint that there might always be some sort of or content that is in the machine. And next slide, please. Well, this very issue is highly unwanted by the developers, as it is supposed to create its own images. But as can be seen on this slide, we have multiple examples where we can see high similarity between the actual output, which is in the upper row, and the training data set in the lower row. So, for example, when looking at the second picture from the left, the blood-borne character in the picture above, you can see that the general atmosphere, the whole setting of the picture, and even, for example, the weapons holding in the character's hands are very, very similar, and likely even color scheme and everything. And looking at the next picture with the phone, or for example, the sofa in the back in the last slide row, you can see that the AI system, what doesn't it? You can see that the AI system simply copied the very setting itself, just exchanging smaller elements in there, like the picture, the colors, or just the phone case. But overall, it is simply copying the syntactic data. So this is highly unwanted and is still under research by the IT, trying to figure out how to actually bring out data out of a model. Depending on that, our discussion might actually be quite changing in the future. Okay, next please. Here. Okay, now we come into different AI or artificial neural network architectures, meaning that multiple AI models are put together and working together. First example, which is probably one of the most novel and important models architecture, is the transformer architecture, where multiple layers of encoder and decoders are used together in order to, for example, process language. In this case, the very task is to translate the sentence "Optimus Prime is a cool robot" into Japanese, which is in this "Konvoi wa kakkoi robot desu." By that, this task itself is not quite simple, as one has to see that the language structure in Japanese and English is very different. So meaning that, for example, the verb is at the second position in the English version, while the Japanese version puts it at the back of the sentence. Also, the difference in naming, as Optimus Prime are two words that are put together in a very meaningful way, basically giving us the name of the specific robot, while the Japanese name is Convoy. So the model also has to recognize these words as one and put them together and actually translate them. Just not knowing it simply by heart and translating every word by word sentence, which would make this whole sentence very unauthentic, but actually putting attention to the different interaction of the sentence parts. It does that by creating hidden states for all of these single words, letting them pass through all of these levels of encoders and decoders by feeding them forward and putting self-attention to each of these parts in order to kind of figure out how they relate to each other, and then creating an output that is more authentic from a human perspective. Okay, next, please. Another example, and this is probably another well-known one, is the generative adversarial network, or short GAN. Where we have two different AI models interacting with each other. The first one is the discriminator, which is trained on real data in a supervised manner, what has the task to discriminate or kind of figure out if a picture is an actual picture or if it was generated by AI. The generator has the task to convince the discriminator of the image being a real image and not simply generated by AI. And it does that by generating an image, sending them to the discriminator, and that one will then label it as real or fake. Now, if the generator loses, it will receive input by the discriminator, again being trained on that very result in order to create better results by the next try. While the discriminator, if it loses, is also trained on that very material. And the output then can be used in practice. Okay, next slide, please. Another architecture that utilizes encoder and decoder are called variational autoencoders. These are a bit older model, I think from 2014, if I'm not mistaken, that has latent or utilizes latent distributions. An example of this so-called latent space is on the right, where data is represented quite statistically on these specific nodes, where each node represents a, well, different, in this case, font that can be used to then recalculate and generate a certain probability. As you can see, the data goes in, the encoder part creates a certain latent distribution, which is then sent to the decoder through bottleneck position. That then is decoded and well, actually generates the image as can be seen in the last picture. Okay, next slide, please. Okay, now having together our model, or having put together our model, the question is what comes then? Generally, the model at this point should be able to fulfill its specific tasks, but still, so depending on whatever that task is, but still needs constant evaluation, or otherwise the model drift might occur. A model drift generally is the idea that a model might not be up to date with, for example, new methods of email spam or changes in society that kind of force us to have a completely new recognition of humans, for example, when wearing masks. In that case, the AI model might not recognize a human if it is very much trained on faces. So in that sense, we still have to continue training and developing the AI model. Next slide, please. Yeah. Another issue, and well, that generally is not fully understood yet, but there is the issue of hallucinations. Now, what happens if you ask a model a question that seems not to be included in the data set? Generally, what might happen is, in this case, what has been done was to ask the model what is actually the capital of Mars, which, well, for human, that obviously is an answer that is none. Well, what happens in that case? Generally, the AI tries to rely on the training data, figuring out different pieces, and then creates a sentence that might not fully, from a human perspective, make sense, as in this case, the sentence, the capital of Mars is Elonville, comes out of the box, well, leaving us kind of puzzled why that happened. The problem is, well, this very specific issue is, well, easy to handle for us, but it can be more problematic when it comes, for example, to legal analysis, asking a model to analyze a specific case or giving us cases. In that situation, the model might actually make up some information. In that way, we have to be careful when dealing with AI models and such specific issues. Next slide, please. Well, I actually tried to ask the system the same question again, and as you can see, it has developed so far that it recognizes this issue and responds that Mars does not have capital since it doesn't have a government or cities like Earth does. In general, why the answer Elonville might have come up is probably because Elon Musk has the space colonization program. It's probably often mentioned in the context of Mars, and also the development of Elonville, I think in Texas somewhere, is also there. So probably the model just put these information together. Now, when I asked it, do you often hallucinate? The answer was, I don't really experience hallucination in the way humans do, which is probably the quite accurate answer. But it then continues, but I can sometimes generate incorrect or misleading information. It's not intentional, it's just a quirk, how I process language. If something feels off, feel free to ask for clarification. And that exactly is the answer. We have our data set, and the AI model is trying to kind of not really reading the actual data, but actually reading the numbers. So for example, if you ask how many R's are in a specific word, it might not answer correctly as the numbers simply do not align in the correct way. Yes, next slide, please. Now, the actual question is all of this relevant that I'm mentioning? Well, the answer is, as can be seen by this very slide, the answer is yes. Looking at EPO data from 2008 to 2018, we can see quite the rapid increase of AI patent growth in international patent families of our AI. Starting quite slow with 41, going up to 55, and then continuing, well, like a lesser within 2010, but then continuing to grow from 2011. Now, when looking at very specific events that happened during these years, for example, in 2011, we can see that the first CNN was developed by Jürgen Schmidhuber, which actually won the German traffic sign recognition competition. It's a very specific case, but also Siri by Apple was developed in that specific year. And going to, for example, 2014, where we can see quite the increase. That was the case when Goodfellow developed the gun, and Kim Welling developed the variation autoencoder models, still leading us to new inventions. Now, 2016 was also the case that the AlphaGo machine was for the first time able to beat the champion in Go. And going even further, we can see quite the explosion in 2017. That was when Vaswani et al. Released the paper, "Attention is all you need," basically giving us a first insight on the transformer model that is quite relevant for practical purposes. Next slide, please. Now, the problem was that I wanted to figure out actually what is coming after these years. And the EPO didn't supply me with quite the data on AI, or AI specifically. The only thing I found was the patent report from 2023, which showed us still quite an increase in computer technology, but also other fields. So I couldn't quite figure out, also only with effect for Germany, but generally it's quite the interesting data set we can have a look at. So first of all, what is shown here is the patent application with effect for Germany in the field specifically of AI. So meaning that both the application at the German Patent Office, but also the EPO are mentioned here. Generally, you can see continuation. Just for relevant information, the first slide showed the growth in percentage, while this one actually shows the numbers of applications. And we can see quite a high number with 6,691 application already in 2019 that grew over 9,000 in 2020, still showing as an upward trend as quite the recent developments still happen when looking at generative AI. Next slide, please. Okay, there we can see a distribution of market shares from different countries, and these kind of
Sorry, ich habe die Opfern gesprochen, das höre ich gerade selber ab bei mir.
Sorry. Oh, okay. We can see different market shares of different countries, specifically now in Germany, but they kind of translate to the international level as well, where we can see that the United States generally have the leading position in the market with a share of over 30% and a growth rate of 3.7% in the year compared to the year from 2022 to 2023. And for Germany specifically, Germany is at the second position in the market with a share of 17.1% and a growth rate of 5.2% with 1,604 patents. What can be seen internationally, though, and also in Germany, is a trend that China and Korea actually take over this market, or at least we can see quite the increase in patent application with 15% for China when comparing it to the year of 2022, the 10% market share, while Korea has an increase of 10.7%, showing us the quite fast development in these countries. This is also a danger for Germany to lose the hold on the market if these countries develop even faster. Next slide, please. Now, last but not least, a slide focusing on the different applicators in our patent field. For Germany specifically, the most important or relevant actor is the Robert Bosch GmbH with 378 applications. Although second already comes China with Huawei and 281 applications, followed by the United States with already on the third and fourth place Google and Microsoft, and last but not least Korea with Samsung, showing us quite the trend and development. And with that, I would like to hand over to Markus, can now focus on the patent perspective, which, as seen by the data, is quite relevant for practical issues. Thank you for your attention.
Yeah, thank you, Hendrik, for this very appropriate and very extensive overview of the technical background of our today's webinar's topic. And Niclas, also to you, thank you very much for the introduction of our panel. So continuing now within panel 1, I would like now to share with you some insights about the patenting perspective on the whole topic. So where do we come from? Maybe taking a step back in this regard to the mid-20th century, where we were talking about hardware only in the end, yeah? How to connect electrical components like transducers and so on with each other. Of course, only hardware in this regard, first of all. And then, of course, taking a step further on, according to the common understanding, what is the software, what is code, what are algorithms, and so on and so on. And then in the end, of course, in the last, let's say 20, maybe even 30 years, taking step by step into the area of artificial intelligence in the end, with certain models in the meantime being established, like machine learning, deep neural nets, and so on and so on, what now Hendrik already elaborated on. What you have to understand probably in this regard is that the common understanding is, of course, not the one which we as rather heavily involved people in the development area are talking about. So really taking a step back and looking at what is the common understanding of society about the whole topic may hugely differ from what we might expect from the topic as well, in our terms and in our view, of course. So after having now set up a first definition, maybe from the society's level, overall and general level, we need, of course, to take a look at what does the EPO, as one of the major patent offices throughout the world, of course, says about how software, how AI is to be defined in the end. And when you take a look at the guidelines, you can find the respective definitions. Of course, probably to the most of us, the computer implemented inventions and the definition thereof by the EPO will be already well known to, referring to computers, networks, and programmable apparatus, and of course then also mentioning computer programs in the end. I mean, already in the last 10, 20, 30 years, this has been well-established definition in the meantime. But of course, then at some point in time, the question came up, what is AI now referring to? Is it to be seen in a different way? What is the impact of it on such definition? How can it be tested on the criteria for patentability? And maybe to put it in a nutshell, the EPO in the end put a rather pragmatic way, how I would at least formulate it. They connected it directly, according to the real life, more or less, to the software definition, which was now presented to you before. In the end, it's also referring, in respect of this definition for AI, to computational models and algorithms, of course, what it is. Also putting down terms like classification, clustering, regression. So what you really do with it in the end, in real life as well, why you also apply them to your issues, to your problems you want to resolve by establishing and by implementing AI in the end. And yeah, what the EPO also mentioned or mentions in this respect in the guidelines is it's per se abstract. That's what it is. It's still kind of software, of course, and so even if you train it, this does not necessarily mean that by applying training data, there's a completely different means available. It's more or less still a software, still considered under the same aspects according to the definition. So now taking the step to what is to be considered when talking about or when considering testing of criteria for patentability. The EPO, in its landmark decision, how I would call it at least G1 from 19, set up a final, more or less final, surrounding how to examine the patentability of such inventions and such subject matter. Why this is not a final one, not a final decision, not a final definition of how to examine patentability, I will come later to on. So what is going on now? How are these patentability criteria tested? Of course, the EPO calls it a two-hurdle approach in its guidelines. Why is it a two-hurdle approach? You can see already here two parts being outlined. On the one hand, the non-invention criteria according to Article 52. Of course, there can be no invention which is per se excluded. This is also what the definition of the EPO, of course, refers to. On the other hand, it has to fulfill, of course, the novelty and inventive step criteria to be patentable in the end. And so by this decision G1 from 19, the EPO stated in the end that the criteria, according to, for example, the COMWIC approach as used for software evaluation, also has to be applied to AI-related inventions. So now maybe in a more illustrative way, two-hurdle approach. Why is this tested in a two-hurdle approach and how I call it now in the header of the EPO in 3 steps? There's a certain point in how to examine the second hurdle, of course. First of all, hurdle 1, as mentioned, are there any technical means at all? If no, if there are no technical means at all, then of course you cannot meet the criteria of patentability overall because it's excluded from patentability. If this first hurdle is answered with a yes, you step on to examine novelty and inventive step. Again, novelty, if you have any kind of technical feature available in your claim 1, then you already passed this hurdle, more or less with respect to the prior art as being a differing feature. But the question is now, how do you test the inventive step hurdle in the end? And this is where the real deal comes on before the EPO, and the COMWIC approach is, of course, applied also with respect to AI-related inventions. So what is now the matter about this COMWIC approach in the end? What are we looking at? What are we referring to? The question is, when you take a look at the claim language and overall, you have to delimit or to separate the technical character features and technical features from the non-technical features. And only the technical features can contribute to your inventive step assessment in the end, with respect to the closest prior art, of course. So are there only now the technical features being considered in this test, or are there any other means which may allow us to further push the boundaries, how I would call it in this respect? And the answer is yes, because G1 of 19 clearly outlines in the end by the enlarged Court of Appeal that there can be such intermediate step where the non-technical character features or non-technical features can also have some kind of influence and interaction which may allow them to be considered as providing still a technical contribution. So this is like pushing the boundaries by overturning or translating features which at first have not been relevant at all into really relevant features, because they can define your broader scope of protection in the end by just having small formulated interactions with the technical effect, with other technical features, and so on and so on. And when this happens, and even if there is only an implicit interaction, it does not have to be necessarily be mentioned as an explicit interaction, but only an implicit interaction would already be sufficient to have such contribution to the technical character of the whole invention. And in such case, also the non-technical characteristics or features can be considered, have to be considered according to the EPO's approach for the inventive step. Further on, what you have to mention as well, and this is where my previous reference to is G1 from 19 really a final decision. The decision itself leaves it open what the term technicity is indeed referring to by explicit reference to developments within society, within technical developments, and so on and so on. So G1 from 19 already indicates that there will be changes in the future about how technicity has to be assessed, what will happen to such term in the light not only of technical development, but also how society takes a look at it. So coming back to our graph from 2 slides before, what does this mean? In the end, more or less, I tried to pull features from the bottom line here, from the non-technical character, into the assessment of obviousness or non-obviousness, of course, in order to limit my invention and my claimed subject matter from the side of prior art, and especially, of course, from closest prior art, thus giving me the opportunity to push the boundaries, as mentioned before, and to have some kind of very, very broad or most broad subject matter and scope of protection in the end, of course. So what are further requirements with respect to assessing patentability and allowability of such claims, having implemented AI, making use of AI inventions, and so on and so on? So there are several facts which have to be considered. And why are these facts highly relevant? Yeah, because Board of Appeal decisions really step into these aspects and these topics when making decisions whether an invention implementing AI is allowable or has some downsides, which oftentimes can lead to just the applications or even granted patents during opposition proceedings being rejected again, or in the end being declared null and void. So what are we looking at in this regard? Yeah, so from A to E, of course, things like mentioned before now or elaborated on already, the technical contribution of single features, then the requirements to be met not only within a certain part of the claim, but throughout the whole claim. In the end, then the well-known issue of clarity, of course, and then things as well like enabling disclosure and plausibility or credibility of the technical effect. So these are really decisive points which you have to take care of when drafting patent applications right at the beginning, because in most and an overwhelming number of cases, you cannot fix it anymore after you have filed the patent application itself, especially if you are already like in the oral hearing or in opposition proceedings. There's sometimes no way out anymore to fix this anymore. And in the following slides, I want now to outline a bit more about the points A, B, D, and E. Skipping, of course, clarity now. Why? Because it's rather well known, and of course, all the different parts, A to E, they are more or less also interacting with each other, and it's not always clear where to put the single issue to. But as we all know from the everyday practice, it's more or less a sliding variety between the different points. So starting with technical contribution, as mentioned before, yeah, what we indeed try is just put a certain technical relation into your wording in the end, to have this cross-border between non-technical feature, but still assigning some kind of technical contribution to it in order to be able, in the end, in front of the examining division or the opposition division, to argue some kind of technical interaction or some interaction with other technical features or with technical effect, at least implicitly. And how can this be done? It's sometimes rather easy. As you can see now with regard to my example I put down here on the slide, instead of just calling it a parameter, just put a reference, at least in the description, to what kind of parameter it is. Where's the use case referring to? And this can already provide you with the sufficient interconnection to the technical issue being resolved by your invention. If you skip the use of application, for example, or even only the small word of control here in this example, you may not be able to fix this afterwards again. So coming to the wording and the disclosure, in the end, this may be of crucial importance for your success before the EPO in the end. And please use descriptive terms in the end. Taking a look at what the requirement within the scope of the claim has to be taken care of. There are several decisions, and I pointed out or mentioned 3 or 4 of different kinds of decisions now by the not only by the enlarged Board of Appeal, but also by the Board of Appeal. And some of these cases are really referring to such more or less, in the end at least, obvious issues like you need to be able to exercise and to work out and to have this technical effect throughout the whole scope of the claim, not only in single cases. And there are cases where it was more or less, or could have been, obvious from the beginning that there are some downsides which in the argumentation which lead to the claim being not exercisable anymore for certain reasons, or the technical effect being not achievable, only maybe virtually, but not in real life, when taking the whole scope of the claim in consideration. So this also leads again to descriptive language within not only the claim itself, but especially also in the course of the description, of course. If you have a certain use case you want to apply to, please mention this use case. This may be your final fallback position in the end to save your application during the examining procedure and proceedings. And what's also very important here is when taking a look at the last or penultimate line of the slide, also make sure if you have boundary conditions for process, for example, these should be mentioned at some point throughout the description at least, in order to have really sufficient disclosure of the whole setting and the circumstances I usually like the comparison to some kind of experiments in laboratory surroundings. If you have a certain chemical process, you also have to define boundary conditions, of course, if they are not already set down by the reality itself, like temperature, like clean air or whatever, then you have to define them, of course. And if you don't define them, you would and only give the ingredients, like 40 different ingredients, you will probably not come to a certain conclusion in the end. It's the same with algorithms for AI in the end. Okay, this also cuts into the issue of enabling disclosure. As mentioned before, the different aspects, formal aspects, are interacting with each other, of course, and reproducibility is also in rather straightforward topics, maybe like mechanical engineering, well-known issues, which sometimes may cause problems during the examining proceedings in the end. And yeah, if possible, please mention where your training data come from. If they contribute to the technical effect, you shall mention it in the end. If you don't do this, if you don't mention that your training data are particularly shaped or prepared or whatever, it's still a black box and it will not be feasible for a skilled person in the end to come to the same technical conclusion and to the same technical effect, of course. What's also have been discussed in recent years and what was part of the decision G2 of 21 is the question about training data and do they have to be like disclosed in an extensive way? And the clear answer is no. This is usually not necessary. It's only necessary to disclose certain parts of such training data if they have a particular shape or if they are prepared particularly and they contribute to the technical effect. So if there's something going on with your training data, with the training method in advance, you shall outline this during the description. And then, of course, again, topic of explicit disclosure. This is referring to the same issue. If there are boundary conditions, please make sure that they can be mentioned in the description in the end in order to ensure the reproducibility, but in the form of a recipe for the skilled person how to exercise the invention finally. Now coming to a point of plausibility, or how the EPO in the meantime tries or wants to call it, it's about the credibility of technical effect. So only because there could be a technical effect by your invention or by your subject matter being claimed, this does not necessarily be the case or being proved according to the disclosure. So also in this respect, please make sure that you outline what is the technical effect and why it occurs over the prior art. And this is again referring to my example from chemistry or laboratory surroundings, exercising certain things, certain trial and error experiments, for example. If you don't put down the conditions, the surrounding conditions, you will not be able to exercise the tests appropriately and come to the same conclusion as it may have been outlined in a rather too general way in such patent application. And coming back again to the topic of G2 from 21 and the issue of whether data have to be mentioned and so on and so on, training data, for example, I want to point your attention to the guidelines in this respect as well, where the EPO clearly states now in the meantime that yes, you have to provide some information about your data. You cannot only rely on mere allegations, but of course, you don't have to like provide mathematical proof, bulletproof proof more or less of what you are doing there. It's more or less sufficient to give a certain to arrive at a certain hurdle in the end. And if it comes to specific training data itself, they do not need to be disclosed in full extension, but what you make use of during a technical invention and a technical effect thereof, this should be outlined to some extent at least. So now the question is, what is to be considered when you hit up on such issues during examination proceedings? How can you work around it? What can you do in advance to avoid maybe such issues when it comes to the question, is the application finally rejected or will you be still successful? And this is more or less a summary of what I now mentioned during the last slides. If you have a field of application, a specific use where you want to apply your technical invention to, please mention it in the course of at least the description. If you have some particular advantages of your technical implementation, mention it. Don't hold back in this regard, because you may have to use it in some ways you would not have anticipated according to the previous procedure being applied in usual inventions, like in mechanical engineering or whatever, doesn't matter. But here in the regard of software and implementation of AI, this may save you and your application in the end, because you can provide sufficient clarity, you can provide sufficient credibility of your technical effect. That's what it's about. And then also try to make direct connections to physical effects in the end. Try to mention them as far as possible, because again, this will allow you to argue in the end before the examining division or the opposition division that there are some interrelations of maybe even non-technical features contributing to your technical effect, thus leading to the situation that the opposition division or the examining division has to consider also such non-technical features for the assessment of inventive step. Vis-a-vis, of course, then the cited prior art. So finally, the closer context of the invention can be or become decisive when it comes to your success rate in examining proceedings or opposition proceedings. Turning around now, what kind of options do I have when it comes to forming my claims? And yeah, are there maybe some differences with regard to classical technical areas? And the clear answer is, of course, yes. And a lot of us will know about it already, because there are certain publications going around, not only in the established form like EPO disclosures and publications, but also over LinkedIn and so on and so on. So, of course, this is not only referring to indeed the prosecution proceedings, but already also referring to the litigation things I will come to a bit later. So what can be claimed in the end? And this is indeed mentioned by the EPO itself as potential subject matter. We can not only refer to the device and system itself and to the process or method, how you want to call it, but also to the computer program, product, and to such things like a computer readable medium or storage medium, which will not lead to any kind of objection due to lack of unity. So these are at least the established means I can call for. I can request when filing my patent application, and the EPO will not object to at all. Already mentioning or having already mentioned the litigation topic or the litigation considerations, in this respect, we also have to talk about cross-border systems. This is decisive from my point of view, really decisive when thinking about how to draft claims, not only with respect to software, but also to AI, of course. So questions I raise to myself each and every time, what is about the distribution of certain instances of my system? What kind of steps are run through or are executed by the different instances? How is the data prepared? What is the impact of the training data? What is the impact of the output data in the end for my system? And are cloud solutions used? These questions are necessary nowadays to make sure that you get it the right way. And of course, then there are also further topics which may come up in different circumstances or situations. For example, in the course of due diligences like license questions and so on and so on. So where are my AI models, my neural nets coming from, and so on and so on? What about data protection, especially in the medical field, of course, when you talk about or work with medical data, medical patient data? There are also regional differences, of course, for example, within or throughout the European Union in comparison to the United States and so on. And then you have the topic of trade secrets. We will hear about some of these topics later today as well. So how do I cope with it? How can you cope with it in the end? Make clear separations between the different parts of your invention. You have to question yourself, okay, what are the parts of my systems? What are the different instances are doing? What kind of part of my invention are executed by the different instances? For example, in this regard, also mentioned in the guidelines of the EPO in the end, you may have a sending device, you may have a receiving device, they may cooperate with each other. So you have some kind of communication already going on here, but this communication can be executed either cross-border or within a national territory. So you do not know so far. If you only claim the system, you're already out of the game, maybe. And then, of course, coming to the computer program product in the end, the question always, which kind of steps are performed by the several instances? How do they interact? Do they have data transfer in the meantime? So during the different steps, or are the steps performed completely individually? These are all things which have to be considered when drafting the claims itself. Which you should not do is straight away write 2 pages claims where you put everything more or less into it just to make it comprehensible from your point of view, because this will not save you or your client in the end, of course. So always take care that you have like procedural steps being separated according to the individual instances, and then of course also taking care of what happens in real life in a pragmatic way spoken. If you have, for example, a hospital where some medical imaging is going on, then the data may not be examined or worked through or calculated further on within the hospital itself, but maybe they are sent to a cloud solution or to another server, being even abroad, not in the same national territory. And then the finished or calculated data are referred back to workstation within the hospital. And then the examination itself is not executed at the hospital, but at the physician, maybe at a different location within the same national territory or a different one, you never know. And then you have already 4 or 5 instances collaborating, of course, forming a complete system, but not being litigatable anymore as a single one, because you always have like either different users or different providers or whatever. The same as when you talk about, or when we are talking about licensed solutions for software, for example, you never know how this will be established finally in real life. Okay, turning to now the question of what kind of AI systems are really referring to when trying to improve the system itself. And Hendrik already mentioned a lot of things about this one. When you put some rubbish into it, what do you expect to come out in the end? So how do such systems become actually good or better in the end? It's about certain things like training data. It's about training proceedings, training procedure. It's about, of course, then in the course of the development, oftentimes about the verification and validation procedure. So there are a lot of things which are usually not taken into closer focus or perspective as far as I get the discussions going on, at least. Because when talking about implementation of AI, especially in fields like private law firm practice or stuff like that, where do you get these data sets in the end? Yeah, these are decisive questions from my point of view. And as elaborated on before, this may also be decisive for your technical effect being achievable or not, and whether your invention and your subject matter being claimed is finally being considered by the EPO as executable. And then also the question, trained AI model, what is the difference in the technical effect finally? Yeah. So overall and generally speaking, all these points are mentioned more or less in the decision of the Enlarged Board of Appeal in G1 from 19. As mentioned before as well, technicity is still an open concept, being described in this decision as such open concept explicitly, being open to developments within science, within society, and technical developments as well. What you should still take care of and cautious about is linkages. What do I refer to with this term? I told you now about, yeah, you should try to have some kind of reference to fields of application, to technical terms, use descriptive language, and so on and so on. What I refer to with linkages and caution with linkages is particularly not to combine the device or the system itself with the training aspect itself. As far as you can separate such different subjects from each other, you should only make use of trained data, for example, or trained algorithms, but not try to combine the training method with something else, because this will cause problems usually, as you can reread in the decision mentioned here, T1191 from 19. Okay, so a lot of people from us will have heard these citations from clients, from other persons outside the field. Software is not patentable anyway, or that's not possible at the EPO. We know about that. In the meantime, it's obvious that's just not the case, but you need to know how to do it, of course. And the EPO has, in the meantime, rather clear approach on how to assess the certain things about software and AI in this respect, of course, mentioned as one term in more or less, because the EPO really assigns AI to the field as, or at least as a subfield of software. So I can only emphasize and encourage you to read the decision G1 out of 19. This gives you a really good overview of what the EPO is referring to and why they are referring to it. And then, of course, the well-known convex approach is here decisive for the consideration of inventive step finally. Then you should always take a look beyond usual boundaries with respect to your subject matter being protectable, because there are further things going on when speaking about AI. As mentioned before, we have now the thing with the training data, which may be decisive for your technical effect. I mentioned this several times now, how the methods, how the neural nets or whatever are trained in advance to be implementable for your specific application, field of application, or your invention finally. And this has to be outlined in your patent application if you want to make benefit out of it finally. And maybe even overcome formal objections which you do not anticipate so far when filing the application. Then always take a look at the considerations about cross-border enforcement, of course. As mentioned before, make a clear differentiation between your different instances. How can this be established in the real world? What are the options? And how is this planned to be implemented by the client, for example? Oftentimes they already have some kind of idea that service or cloud solutions shall be implemented in the future. This should be reflected in the claim wording as well. And then, of course, when it comes to the terms and the formulation of the claims itself, to the claim wording, please make sure that you are aware of things like not only the technical contribution of non-technical features, but also of the descriptive terms of things like boundary conditions. As mentioned before, I always take into my mind, or keep in my mind, the topic of laboratory circumstances and boundary conditions in such tests and exercises. And test and training data being decisive for how AI can be developed further on, as Hendrik mentioned before, not only setting it up once and then putting it into the implementation field, but further continuing the development of such model, of such AI model by sufficient test and training data. This should also be considered when taking the approach for a patent application. So far, so good. Thank you very much for your attention. And yeah, if there are any questions for such panel one, Hendrik and me, we are of course open for them and looking forward to them.
Thank you, Markus and Hendrik. A very wonderful presentation, which also gives a great outlook onto the rest of the day. As we will be continuing at 11 a.m. inter alia with regulatory, but also the copyright issues. And I heard you just shortly mentioning that the distinction between software protection and patent protection with regards to AI. And of course, the software part of it is a very different issue and has very different components to it. I'm still waiting for some more questions from the audience, but maybe as a seed question to both of you, Hendrik first, and then maybe to you, Markus, with a little bit of a different aspect. As regards to the black box nature of AI, Hendrik, we have heard a lot about the technical importance of data for AI, and that it must be implementable for a specific application also. So the AI solution in general, it's something that we also learned from Markus. And with regards also to the EPO approach, requirements for patenting AI, such as disclosure, technicality. And Hendrik, do you think, coming from a more technical point of view, that the importance of AI, because of data for AI, because of course you can't use an AI solution without data that actually makes it work. Do you think it is already reflected sufficiently in the patenting requirements, or do you think there is still some leverage there?
So I think when it comes to the development of AI, well, as already mentioned, the training data cannot, or the inference of the training data cannot be sufficiently mentioned. Generally, there are discussions if the training data itself can actually be protected by patent law. At least in literature, that discussion exists. So far, both outcomes are kind of representable. And generally, it really depends if you can, well, either create an invention that is a method in order to gain this training data, or if you can actually present this data as an invention itself, which I personally find rather unlikely looking at the long history of EPO decisions already mentioned. Is that an answer to your question so far? Or,
I think so. Thank you. No, that's a very interesting perspective, actually. Patenting of training data is another maybe future aspect to AI and
yes,
protecting us.
Yeah, but in that sense, the patent law probably is problematic when it comes to the revelation of this data. But yeah, that's the interesting question, maybe even for panel 1 at this point.
Very exciting. And Markus, we've heard about the classical patent claims that can be used for AI. Do you think they are suitable and they are sufficient? For example, system claims, method claims, and so forth? Or do you think there's maybe even room there for AI claims that then build onto that?
Yeah, probably we will see in the forthcoming years that the applicants will strive for a bit more exotic subject matters in this regard, because I think what is going on now, the AI landscape itself has been settled down a bit in recent 1-2 years maybe, and now it comes to how to prepare the data, how to train the models, and so on. So this is of more relevance in the meantime than maybe 5-10 years before, where everybody was a bit curious only about what kind of algorithm is underlying, so what kind of neural net is used, and so on and so on. And now what comes or becomes clear in the meantime from my point of view is it's about the data indeed. This is where the power lies finally, to prepare your data sufficiently and to modify them in a way to make the model not only work at all, but more efficiently, to be more stable, and so on and so on. So I think putting focus on what kind of data are used, how they are prepared, how they are also developed over the time. Yeah? Not only like a one-time shot, but as a continuous procedure to keep your model working on the same level, so like progressing in its quality. This is what I mean with the same level, not as a one-time shot, but it has to develop over time. Otherwise, it's the same as a one-time algorithm being implemented, and that's it, right? And this is not what AI should be referring to only. So I think, yes, to answer your question clearly, yes, there will be maybe slightly different subject matter, which may become more or will come more into the focus of the applicants.
Very interesting. So thank you both again. I don't see any further questions from the audience right now. Also for your great time management. We're actually, we've been faster than we planned on being, which gives us a little bit more space for the break, which is now scheduled until 11 a.m. And then we will continue with panel 2, which will cover some of the regulatory aspects. So AI laws as they are right now, and also related aspects of IP law, such as copyright in relation to AI, and of course, trade secrets. And we're very much looking forward to seeing you back then. So thank you everyone for tuning in. So welcome back everyone, or welcome if you just joined the webinar. We already had a first session today, first session on patenting and the technical features of AI. And some of you, or at least the ones who have already been with us for this session, know me and also Hendrik, Meier already. For the others, I'll give a brief introduction because we will also be part of the second panel. So my name is Niclas Gajeck, and I'm a patent litigator from Munich at NER. And Hendrik is a researcher at Leibniz University at the chair of Professor Dornes, private law, intellectual property law, and an assistant to the editors of Go Patent. and his research focuses on intellectual property law more broadly, especially patents and copyright. And together with us presenting today will be Jean-Baptiste Leca. And Jean-Baptiste is an associate attorney at Casa Longa. His practice covers all areas of intellectual property law, related rights, trade secrets, unfair competition as well. He has also a PhD in law and developed a specific expertise during that in matters related to the medical and pharmaceutical fields. And he's also a regular speaker at Aix-Marseille University in France and the University of Turin in Italy. So very illustrious co-speakers here. And we will cover not only German law, but also French law. And in particular, we will cover the sectors of competition law implications and the regulatory aspects revolving around AI. We will cover copyright aspects of it, and we will cover trademarks. And for that, let me share you the outline of what will be going on the next 1.5 hours. So starting, we will be with an overall regulatory overview, which will be conducted by Hendrik and me. And then we will have Hendrik and Jean-Baptiste talking more about copyright and AI, in particular with 2 aspects in mind: the protection of AI-created works and AI-related copyright infringement. And the last section will be Jean-Baptiste and me on trade secrets and AI. So without further ado, let's have a look at the regulatory aspect, shall we? So we have seen a lot of EU legislation in that regard, new data and AI regulations, which govern a diversity of topics. We have some aspects which are rather product safety related, and which govern AI as a risky new technology, so to speak. And then we have aspects such as data users, data access, transparency, liability. And many of those aspects already have also to a strong extent have IP implications as well. So mostly they're complementary, but then they also foster typical IP aspects such as innovation and competition, and provide guidance also for companies who are working in the field of AI. And then there's a very political aspect to it as well, which is what I call the democratization of data access. That is making IP more available, making AI also more available, and in particular also the data that is being used for AI, which should then foster, I think that is the overall idea, a data economy within Europe. And that is being done through legislation. And here is some of it. We are seeing the AI Act, which is more on the product safety side of things. We see the Digital Markets Act, which is a competition law tool, or more regulatory competition law in its overall outset, and which also governs data access, similar to the Data Act, which also has provisions for FRAND access to data in particular, so fair, reasonable, non-discriminatory terms. And then we have rather platform-related legislation, such as the Digital Services Act. And then we have an outline for what is supposed to grow as a structure that is data intermediaries. And the outline for that is the Data Governance Act. So these are just some of the data regulation that we've seen, and all of it has direct implications on AI. And that is why we're looking at it also today. So starting with the DMA, this is to regulate gatekeeper power, so a typical competition law aim. And it applies, of course, to the very largest digital companies, which are also designated gatekeepers often. And it is in addition to the EU competition law rules that we already know, such as Article 101 or 102 TFEU, which govern also access to markets, at least under the abuse of dominance doctrine. And we have seen that in the patent landscape, of course, over many decades now, with all of the FRAND jurisprudence in SAP standard essential patent cases. So DMA Article 6 states that the gatekeeper shall provide to any third-party undertaking providing online search engines at its request with access to fair, reasonable, and non-discriminatory terms. So FRAND again. And also in its paragraph 12, we have the FRAND conditions in there relating to software application stores, online search engines, online social networking services. So there's a broad spectrum of fields that are being addressed by the DMA already. And on top of that, and that also brings in a lot of the Internet of Things services and providers, comes the Data Act, which will also come into force step by step over the next 1.5 years or so. And it addresses the challenges that are being posed by the fact that a lot of the infrastructure for AI and data is in the hands of some very large companies, of course. Also not European companies, if you look at it from a maybe competition or European Commission point of view. So from an international perspective, you might argue this is also a tool to make the data held by these entities available to maybe small and medium-sized European companies who, for example, have an AI idea or solution, but can't really use it without having access to all of this data that is being held, for example, by Amazon or Google or Microsoft and so forth. So again, we have fair access, and it applies to business relations. And in those, as specified by Article 8 Data Act, data holders obliged to make the data available to the data recipient under, again, fair, reasonable, non-discriminatory terms and conditions. And Article 9 again states with regard to any compensation agreed between a data holder and a data recipient. So this is a very, very broad scope of application. Then FRAND terms apply. So this is very thorough data litigation, and it governs a lot of contracts, or will govern a lot of contracts that are being made in this field. We've also seen it now, coming back to a German national legislation perspective, data access being taken into account in the German competition law, the GWB, especially when it comes to assessing market dominance. So the undertaking, that's Article 18, paragraph 18 here, the undertaking's access to data relevant for competition is one of the points that is being assessed when the agency is considering whether or not an entity is dominant in a specific market, which of course is a requirement for taking action in that market. And we've seen in paragraph 19 GWB that also refusal to supply data or grant access to data, networks, or other infrastructure can also be an abuse of market dominance. And again, that can lead to consequences. That can also lead to civil lawsuits, of course, but it can also lead to agency action against the entity, which doesn't allow data access, for example, for the purpose of training an AI to provide specific services in an aftermarket. So the overall aim of the European and German competition law there is very much the same. Yes, and this leads us maybe to the overall issues again. We have several challenges to AI that are being addressed by data regulation. Determining FRAND terms, of course, is a big one, because we've seen in patent law how much you can actually argue about what is FRAND and how many different approaches there are to FRAND. And we've just seen assessment being done in the UK. We've seen assessment being done in China. We are now seeing the UPC opening up to the idea of assessing at least the offer provided by the patent holder. And maybe on a similar level, the Higher Regional Court Munich doing something similar, also thinking about looking more thoroughly into the offer, at least in some circumstances. So the debate is still ongoing with regard to FRAND in the national venue, with relation to patents as well. And it will be very hard to establish FRAND for data. I think that can be said. Yes, I've already talked about ensuring fair competition. We've talked about enabling smaller players, startups, to participate in an AI environment. these are all issues that are being addressed also by this regulation, because these are the entities that are supposed to request access and then be able to even sue for access if they don't get the access to the data that they need to provide their solutions to aftermarkets or even competing markets, some instances. Innovation, economic growth, we've already talked about that, and inclusive and accessible AI landscape. I think that's an overall aim. That's also something that maybe even the AI Act and regulation in that regard is addressing. So if we want to bring it down to one depiction, maybe that's a good one. We have access claims regarding AI relevant data. Then there is an AI owner as well. And there will be output in the form of IP and trade secrets, and that can only be generated, of course, if you have the access to the data in the first place. So we'll have there is a downstream relationship from data towards AI, towards products, and further IP and trade secrets, even which are generated or can be generated on the basis of this data. We've seen that, for example, in the pharma biotech space, where some solutions or some derivatives or some new proteins are being discovered via AI based on available research data. And that may be possible in other fields as well, depending on the data that becomes available through this legislation. So with that, I think, Hendrik, it's a good place also for you to take over.
Yes, that's true. Well, now taking over from the data perspective, we will go to the AI Act. But still, transitioning is hard. We will focus on the data aspect in the AI Act as well. Now, specifically looking at the obligation for providers of general purpose AI in Article 53, we've seen the definition of AI, general purpose AI models in the very first panel now. We can now have a look at the first obligation, which is in literal B, relating to data. Generally, it's seen that the provider, or basically the developer of AI, has to keep up to date and make available information and documentation to providers of AI systems who intend to integrate the general purpose AI model into their AI system. Basically, seeing now this downstream issue again, that a developer who then kind of supplies the provider with its model, who then has to integrate it in its system, has to utilize data in order to actually do that. And the problem that arises with that is the question of spying on confidential data, since this data might be necessary to actually integrate the model. Still, the AI tries to balance these interests in the next sentence, saying without prejudice to the need to observe and protect intellectual property rights and confidential business information or trade secrets in accordance with union and national law, the information and documentation law, and then contain different issues. Yeah, so this balancing is a whole theme for the AI itself. Next slide, please. Now, taking it back from a very specific regulation, we want to have a more general look at the AI at first. Generally, I think this is probably known at some point, the AI Act has some risk-based approach, where basically a pyramid of risk is established, and depending on the step you're in, you will have further or less obligations concerning your high-risk system. Now, with that come also transparency obligation. An AI developer must provide clear information about the systems, including training data and algorithm use, exactly the balancing issue we kind of already mentioned briefly. Data governance is also quite the issue. The idea of having high quality data is necessary, as is already seen in the first panel, for the development of AI. And with that comes a liability framework for those developers, meaning that if they violate their obligations of the AI Act, they might be liable for an administrative fine, similar to the GDPR regulations. In general, what has to be said about the AI Act is that it does not regulate the AI model itself, but it rather focuses on the circumstances around it. So how do we bring it to the market, the product safety that has already been mentioned, that idea. Next slide, please. Now, further obligations that have to be mentioned in terms of data and AI is the disclosure and transparency obligation, which will be themed in the further parts of this very panel. where developers may need to disclose information about their AI solution and training data, potentially being trained such information, especially when looking at patentability. This might be an issue if you publish your data too early on. Now, also, they have to balance this transparency and IP protection, as mentioned. Generally, there's also an obligation to have a policy to watch the European IP protection, especially copyright, which will be mentioned next soon. Besides that, there's also liability for IP infringement, which very much relates to this obligation, where developers of AI systems also ensure that their systems do not generate content that infringes their existing IP rights. And these very issues can technically also be solved by copyright itself, as long as it applies, which is another scope of application question, which we will deal with as well. In general, what has to be said, the infrastructure, in order to give specific answers for all the questions the AI raises, is still not there. Well, it is being built at the moment. So there are still open positions for example, leading research assistants and such in these AI administrative bureaus. Next slide, please. Now, we've seen a similar slide in the very beginning. It is of the same paper, basically, and just sets this again in contrast to other developments of technology in the IP4, the 4IR region, meaning the fourth industrial revolution, which is generally said to be fueled by data. As can be seen, the growth rate is quite high for just the specific AI inventions in this very field. Which is the blue line going up, while the other one stays quite moderate, as the same. Generally, the average growth rate of these AI products is quite around 20% in average, showing that is highly relevant. And this leads us to the question whether we deal with, or how we deal with this new explosion of technology, giving it back to Niclas.
Yes, thank you. And we're already seeing the market react. So we're seeing the legislator react. Of course, we have discussed this earlier, but we're also seeing the market react. And one reaction is, of course, also AI standardizations. So both in a regulatory way, so conformity assessment, certification programs for trusted AI. People are building AI solutions that are aligning with each other to meet the regulatory demands. Then also we're seeing alignment in terms of infrastructure, because we will have to have an infrastructure that and application interfaces that allow data being shared between those different realms of AI and data. Quality standards as well for the development and validation of AI systems. These are all more or less regulatory, again, rather relating maybe also to the AI Act, to product safety concerns, issues. And going forward, there's of course also the need to develop safe and trusted AI applications for specific purposes such as mobility, modeling. We have to understand the human role in the whole system, and this is maybe one side of AI standardization, but there is also another one, and this is more closely related to the patent space, of course. We're going back to standard essential patents in that regard, because we're also seeing standardizations in terms of beyond this conformity aspects. Again, this is maybe relating to the last slide. We're seeing also the standardization in terms of technical standards being drafted and being brought up. So in terms of standardization for transparency, legal certainty, contribution to innovation, the regulatory aspect is important, but there's also a very, very important market for standard essential patents in the AI space, or maybe even a future patent litigation finance market as well, as soon as there are standards in place which govern many or most of the AI solutions, which govern central aspects of AI technology, patented aspects in that regard. And then we will have similar discussions and similar situations, similar disputes going on as we have now, for example, in the telecom space. So this isn't too far away because we're already seeing relevant actors drawing up standards and gathering patents for the purpose of what could be in the end patent litigation against AI providers or AI service providers and so forth. So we see a lot of challenges that companies in the AI space will have to look out towards and that they will have to orient themselves towards. And the regulatory aspect, of course, is one. Transparency, legal certainty, contribution to innovation. But the standardization goes beyond that, and the standardization might even become an issue in terms of having, for example, patent pools with an AI portfolio coming after you as an AI operator or AI user even, potentially. So this again relates to aspects that we've already discussed. So the underlying aspects of the regulation, the issue of safeguarding our European legal standards in light of AI models being trained often outside of the European Union by American companies, for example, also Chinese companies, other companies who are big in the market. And the scope of applications of the regulations is, of course, chosen so that these models, these operators, these entities would also be governed by it. And we've seen this both in the AI Act and also in other IP legislation. Which brings us more or less also to the second part, and which will take us a step back with Jean-Baptiste and Hendrik Meier to maybe less controversial issue, but also very exciting issue of copyright law and how AI is being dealt with under copyright law currently, and maybe also towards outlooks for AI and copyright in the future. So looking forward to that.
Thank you. Thank you, Niclas. Thank you also for inviting me to join this webinar and offer the possibility to create more interactions between the French and German AIPPI young members. So I'll be discussing the topic from the perspective of French law, but I believe there are many bridges between our respective legal systems. In any case, I think it's important and also necessary to reflect together on how each of our national laws might address the many questions surrounding AI. So the first question that comes up when it comes to artificial intelligence and copyright is whether it's eligible for protection. In France, there is currently no regulation specifically addressing the copyright protection of AI-generated creations. At first glance, generative AI could seem incompatible with copyright law. And in fact, under our human-centered approach, only a human can be the author of a work, as intellectual creations must reflect personal expression through free and creative choices. So copyright, from its philosophical conception, is a humanistic right. This is precisely why we call it in French droit d'auteur, or author's right. So it seems on the surface that AI-generated content like text, images, or music wouldn't qualify for protection. However, the situation is nuanced when humans interact actively with artificial intelligence. Through specific creative prompts that guide the AI, the result could bear the author's personality, making the AI simply an instrument in the creative process. This principle, where technique is secondary to human creativity, isn't actually new. Tools have merely evolved from chisels and brushes to cameras and then digital softwares and now to AI. But the critical factor remains the presence of precise, creative human choices. Now, a visual example of this photography. As AI programs get more advanced and accessible, they're starting to blur the lines when assessing the creative process. This is particularly the case in photography, where some AI-generated images have stirred up controversy. Here, German photographer Boris Eldachsen, sorry for my German, won the Sony Words Photography Awards with this black and white portrait of two women who don't actually exist. They were created entirely with AI, and the image eventually tricked the jury. Eldachsen later revealed the hoax and declined the prize. This illustrates that eligibility for copyright protection should not be excluded a priori for this type of work. In fact, there can be some confusion. But then moving to the next slide, if we consider these as intellectual works, how should we assess their originality? No court in France has yet ruled on this matter. As you know, China took a clear stance in a decision dated November 2023, where the Beijing's Internet Court awarded copyright protection to a work generated by Stable Diffusion and decided that the author's aesthetic decisions gave it originality. And this approach which is focusing on human input, aligns perfectly with the principles of French law. We also have a decision from the Bordeaux Court of Appeal stating that what matters is not the method or the means of creation, but the originality intended by the author, which can even be reflected in something as trivial as a bottling line, for example. The standard is thus minimal, and the key question is the following. Has the author exercised some form of control over the creative choices so that the work bears the imprint of their personality? Figuring out originality doesn't solve the trickier issue of who owns the rights. And I'll be moving to the next slide here. Several options have indeed been explored by French scholars regarding this aspect. I'm just yeah, it's the next one again. Perfect, thank you, Niclas. So the first option, which might come as, I would say, the most obvious, would be to grant ownership to the owner of the AI engine. But that ignores the fact that under French law, intangible property doesn't automatically, does imply to confer ownership to the natural person creating the software. But this reasoning is not completely satisfying because in our case, the generated works result from algorithm and or other functionalities which are excluded from software protection and cannot be monopolized per se. This brings me to the third possible option. In the next slide, which would classify AI-generated works as collective works. To be considered as such, an AI-generated work would need to first be created at the initiative of a company that discloses the work under its direction and name. And second, that such work merge together contributions from various authors with no possibility of attributing to any of these authors a separate right. And in fact, the AI's process of breaking down and recombining elements can create this kind of fusion. However, a fourth option may still exist. As you can see, there are a few different possibilities that can actually apply all at once, since multiple rights can overlap during the creation of the AI-generated work. And while the output publication might be directed by a company, the users, through their inputs and through their prompts, could also have some rights. And this ties back to what I was saying previously about originality. If the user is actively involved, if he guides the machine through repeated and precise instructions, if an active iterative dialogue develops between the machine and the human, then the role of pure statistic diminishes and becomes secondary to the human mind. Recognizing rights to AI users over the prompt is not automatic, but it's far from out of the question. So we've gone over where things stand under current law, but let's take a quick look at where things might head. A French bill aimed at regulating AI through authors' rights was introduced in 2023 before our French National Assembly was dissolved and triggering the political instability that is currently making headlines in France. So this bill, which was pushed by authors in the creative industries, aimed to clarify the treatment of AI-generated works under copyright law. There is an economic battle behind these questions, and human creators who fear to disappear ask for a genuine value-sharing mechanism. Even though the bill did not eventually pass, we can still get an idea of what was envisioned. The bill indeed proposed several key provisions for addressing AI-generated works. First, integrating an original work into an AI system would require prior authorization. Then the bill proposes a right to remuneration for creators managed by a collective management organization, which would be mandated to represent right holders and collect the royalties related to the reproduction of the works. And these royalties would eventually be distributed to the authors. The bill further envisions a tax intending to enhance creative value. It would be allocated to the benefits of the collective management organizations in cases where AI-generated works would be derived from sources of indeterminate origin. Additionally, regarding more rights, the bill proposed mandatory labeling to indicate that work was AI generated and to cite all contributing authors. So as we can understand, AI can indeed be a source of copyright, depending on the active role of the humans. But it is also a significant consumer of intellectual works. And this brings me to the next question. I mean, I don't know if the next question is directly, or maybe the next slide is not mine, maybe. After? No, sorry.
Well, we will continue with the next question. And thank you for your in-depth analysis. We just briefly go through the German perspective, which is highly similar to the French perspective. So I don't need to fully revise everything on that. I will just keep it very briefly, showing you the regulation in section 2, paragraph 2, reading as only the author's own intellectual creation constitutes work within the meaning of this act. Basically also requiring human interaction, similar to the French perspective. With that being said, the groups also apply under German law. So it is argued that AI-assisted works, where AI simply acts as a mere tool for the author in order to create a work similar, for example, the case with a pendulum that just swings. In that case, AI-protected works might also receive copyright protection, but that has to be decided case by case. Just to remind you of a very specific debate with the monkey selfie, where the monkey himself took a selfie of itself. The discussion was similar there, arguing that that there is no copyright protection since not a human acted. Well, this concludes our output session, and next slide, please, brings us to questions of the input and copyright violation on that side. Now, starting with the main debate on that issue is AI training relevant in terms of copyright protection? And if so, which actions are relevant? Well, for that, I'd like to take the look at 3 different steps, which are similar to panel 1 again, looking at the collection and preparation of training data, analyzing this data, and then the parameterization of the data. Each step is considered to be somehow relevant. The first being a reproduction and transformation of the data in case they are changed in order to make them accessible for the AI model. Then the analysis, or the actual analyzing of the data, which is then the main part of the training, again, reproduction. And the last part of the parameterization, that still is in discussion, where some opinion argue that this is a reproduction or not. Next slide, please. When now seeing a copyright violation, we have to ask if there is an exception that can justify the such an act in first afterwards. Well, going step by step again, if we look at the collection and preparation of training data, well, if we have some transforming or collection of that data, it might be a transformation and thus fall under the scope of section 23, paragraph 1, but which is then exempted under section 3, paragraph 3, which leads us to the case that if the main act is actually justified itself. This could be the case under section 44b, paragraph 2, which is the exception for text and data mining, which will be the main topic of this part. Which it was brought to us by the CDSM directive in Article 4. Well, generally, it is argued that the step either comes in, well, as seen as one step together with the training perspective. In that case, we can justify it overall by this very section, but in the case of the Regional Court of Hamburg, this very step was in itself a concluded matter, and in this case, it could also be a case of text and data mining by itself. Well, the next step then is the actual training, which is the main discussion on copyright protection, as seen in paragraph 44b. Last but not least, the parameterization of data. It is still discussed if this is a reproduction, and if it is so, there's probably no justification for it at the moment. But generally, now looking at section 44b, we can look at or we can build up 3 different questions, which is first, is AI training actual text and data mining under section 44B? Second, if so, does it fulfill the requirements of section 44B, meaning do they fit for this very case? And last but not least, the big question of the 3-step test in international and the InfoSoc directive. Well, generally, the text is quite long, so I would go through step by step, following in the next slides. Please, next slide, please. Okay, now for the first part, and this is probably the main discussion. The majority currently holds it true that AI training is actually text and data mining, but generally I would like to take the other way. So, first question, what actually is text and data mining? Is this defined as means, as the automated analysis of individual or several digital or digitized works for the purpose of gathering information, in particular regarding patterns, trends, and correlations? So the first question we may ask is what data is actually gathered, since we do not actually get the access to the parameterization of the AI when we are training it. So there's already the first problem. The next problem that arises is that this very paragraph focuses on semantic data, which is not protected under under copyright protection in general, meaning the meaning of the data, when, for example, like the correlation and trends. Now, but what we've seen in the first panel with memorization, for example, it is seen that the AI actually uses also syntactic data in order to be more creative or more authentic in a human sense, meaning that the actual protected data is used in order to train the model, meaning there is actually a relevant reproduction. And since this does not fall in the general definition of text and data mining, we already have a problem at this point. In this, this is why I will conclude that AI training is not actually text and data mining, just to keep it brief here. Next part, please. Now coming to the actual exception in paragraph 2, where it is said it is permitted to reproduce lawfully accessible law works in order to carry out text and data mining. And these copies are to be deleted when they are no longer needed. So what this means is, first of all, generally only reproductions are justified, meaning that other actions relating to copyright violations do not fall under this scope. So we need our own justification if that happens. Otherwise, the work has to be lawfully accessible, meaning that it does that you're not passing through technical measures in order to receive the data, for example, paywalls and such. This also means that, for example, piracy websites that upload without the consent of the copyright holder are also legally or lawfully accessible, which is why there's a discussion if these sites should be excluded. But under the current situation of the law, it is not. Now, generally, there's also this obligation to delete data, and this conflicts with the already mentioned transparency and documentation obligation with the of the AI Act, seemingly showing another discrepancy between the actual situation and this very idea of or concept of text and data mining. I have to add, this also only refers to generative AI specifically, not other forms of that. Now, yeah, and also there might be a trend to kind of interpret this regulation broadly, so that the AI developer actually can keep this data set longer and longer in order to, for example, train new models, prevent a model drift and such, making this an empty provision if you would read it that way. Next slide, please. Another issue that arises is the opt-out system that is implemented through this very norm, in section 3, where it is said that this whole section does not apply if the actual right holder has reserved his rights by an opt-out form. This form, in what format this has to rise, is said to be a machine-readable format, which is still open for discussion. The original Court of Hamburg decided that natural language suffices, so you can do it in just general language as well. So actually, the deployer of AI has to use AI in order to identify such opt-out declarations. That this is other authors argue that you have to do it by a robot.txt, for example, in order to prevent the actual scraper bot to access the data. Now, this is also another issue since the lawful access to works are also given to piracy websites, meaning that there is no opt-out option for the author, creating quite a hole for this very provision. Next slide, please. Yes. So now coming to the next issue. So first of all, we decided, or at least in my opinion, the AI training does not fall in the scope of text and data mining, and it also has some issues with the specific requirements of that norm. Now coming to the third question, does it fall under the scope of, or is it in line with the 3-step test of the Article 5, paragraph 5, InfoSoc directive, which reads as the exception and limitation provided for in paragraph 1, 2, and 3, 4 shall only be applied in certain special cases which do not conflict with the normal exploitation of the work or other subject matter and do not unreasonably prejudice the legitimate interests of the right holder. Generally, this provision is applicable due to Article 7, paragraph 2 of the CDSM directive, which explicitly states that this test applies. But if that wouldn't exist, we would have to rely on international law, where we have different sources like the Article 9 of the, 9 of the revised Berne Convention or Article 13 of TRIPS. In that sense, the question arises, do we fulfill these 3 steps? Next slide, please. Well, now coming to the very first step, which is the question whether whether this exception only applies in certain special cases. So generally what this does is to see that the exception that is implemented does not go out of hand and excludes the author completely from actually using his rights. Therefore, it's only special cases are needed. But what does not have to be done with the legislator is state every single case where this law might apply. In that sense, text and data mining is not technically a problem, as it can very much fall under, or AI training can very much fall under the scope, as the text and data mining is a defined case in itself. Coming to the next slide. We will have to focus on the second step. The second step says we shall not have a conflict with the normal exploitation of the work. The WTO panel, which had the first and well, currently probably only a decision on this very matter, stated that this very element has in itself 2 perspectives that have to be taken in account when determining whether there is a violation of this normal or a conflict with the normal exploitation. The first one being a empirical perspective, while the second one being a normative perspective. The empirical means that we have to analyze how exactly the author utilizes his rights in order to gain revenue from this very from his very work. While the second, the normative perspective, also has to take into account how the market develops and how the technological developments occur. So now, when looking from the first part, the empirical part, we have to see that the author already has developed a market for AI training licenses, meaning they make available their works for AI in order to be trained on. With that revenue, if we set the whole system free, we will lose these transactions specifically, thus limiting the rights of the author. Another issue that arises from a normative perspective is that these AI models tend to compete with the market of the original work, since they kind of reproduce the very style of that author, meaning that either lines between real works of the author and the AI might be blurred or confuse the customer in a sense, making the actual human creator less relevant overall, and simply seen as like a database for training data, which would kind of be in contrast to the copyright idea, meaning that already this step has its problems and probably does not be in line with his trend. Next slide, please. Now, assuming we come to this third step, so we overlook the second steps, already existing problems, we can see, or we will have to make an interest balance between the legitimate interests of the author and the public interests. So generally, the test says it does not unreasonably prejudice legitimate interests. Now, the ECJ has decided that this very step occurs, or this very interest is not, the very interests of the authors are prejudiced unreasonably in case the transaction rate is possibly or may be considerably reduced, which would be the case if we argue that there is a market for licensing, which falls then away for the author. So mainly bringing back the same arguments of the second step. Another issue is, against this very perspective, we can hold the idea of the European Union that we want to actually improve on AI systems and develop, become a leading market holder overall. But this might not convince if seeing that this very provision does not see a compensation for the author. In general, you could argue that the opt-out mechanism could kind of satisfy this very need, but it is generally actually a critical problem with a formality obligation or no formality obligation under the revised Berne Convention, which is a whole topic for itself. Okay, so generally now concluding that the AI training is problematic when accounted, or the training of generative AI is problematic when accounted under the section 44B, and we might face a problem with the three-step test. Next slide, please. Well, if we now go further to the question of parameterization and the question if this is a reproduction by itself, meaning that the data that is analyzed and then put into the weights or parameters of the very system, then we'll face a problem if we agree that it is a reproduction. So generally, one has to say the data itself is not saved, meaning such a reproduction is not intended. But the problem is that still works are memorized, meaning they can be reproduced in full or part afterwards. Since this very part exists, simply looking from legal terms, not necessarily technical terms, this can be considered a reproduction of the work, as this very work can be reproduced and made available for the public. Meaning we would have no justification for that, as the reproduction is, in this case, would not be necessary for the actual text and data mining if we assume AI training to be such a thing, but rather it would be a reproduction that happens afterwards, meaning this section doesn't apply. Next slide. And if we take it to the very top of the discussion, we can argue that if we actually have a reproduction inside the model, and then make the model available for the public to access, we also make the specific works inside that machine also available, creating the violation of section 15, paragraph 2 and 19a, the right of the author to make his work available to the public. Since there's also no justification for that, this would also cause problems for the AI development. When looking from international private law perspective, generally speaking, if the AI training happens outside the EU, we do not have an infringing act on the territory of Germany, for example, meaning that we could not rely on German copyright law in order to protect us in this case, since it does not apply. But if this very making available to the public is seen, we can actually also follow up by the international private law, arguing that there is an infringing act on German territory, now that making it able to have author's claims against the machine or the AI developer, basically. Okay, with that, I will hand over to Jean-Baptiste again with a French perspective.
Yeah, thank you very much, Hendrik. As we don't have so much time, and that in fact we don't have French case law with definitive answers to the questions raised by Hendrik, and we have the exact same questions in France. I will not take so long. The first question that is raised is that is AI's use of intellectual work an infringement of authors' rights? Some people argue that there is an act of reproduction, while others explain that there cannot be reproduction since there is no Yes. So I will not repeat these elements which were already mentioned with the two different exceptions, with the second exception, which would be the most appropriate. What we have though is a decision issued by the French competition authority. Which imposed a 250 million fine on Google regarding neighboring rights. So an analogy could be made with between the AI question and the regime applicable to those neighboring rights of publishers and press agencies following the EU directive of 2019. This implied a right to remuneration due to the indexing of press content by services such as Google Search and Google News, and which had led to discuss the appropriate remuneration between the press agencies and Google. While the decision does not provide insight into copyright law itself, it highlights an intent to enforce good faith discussions whenever protected content is used on search engines, and it emphasizes that remuneration should be based on transparent, objective, and non-discriminatory criteria. So we even have some front discussion here. So attention will necessarily be given in favor to the creators of original content that actually feed and train artificial intelligences. And as the three-step test was discussed earlier, this practical possibility of negotiating a license could be regarded also to evaluate whether there is an undue exploitation of the work.
So if we turn to the next slide, then. This is just a German statute, but it's very similar since it's harmonized based on EU law, based on the Trade Secret Directive of 2015. And the German Trade Secret Act, Section 3, describes what can be protected as a trade secret and which acts of discovery, and this is specific to Article 3, are permitted, vice versa trade secrets. Here we have, of course, independent discovery or creation. So one person can hold a trade secret, another person can discover the same information and then disclose it, and then the trade secret is gone. Same can be done by observation, study, disassembly, or testing. So this is already very close to reverse engineering. And there are some limitations to that. Of course, you can't forcefully enter the company sphere of another company and then disclose this information. But if you can can achieve this information that is protected by trade secret law by disassembling, for example, goods or objects that are publicly available, that are on the market, then that is lawful. And then the trade secret right might also be gone, or both companies might hold the trade secret dependent on whether or not both maintain confidentiality. So, and if we then head forward to the next slide, then Jean-Baptiste can give an overview over the situation under French law.
Yeah, French law is not radically different from the German positions here, because then we also have the same EU directive. The three conditions are formulated as follows. In order to be considered as a trade secret, the information cannot be in itself or in the exact configuration and assembly of its component generally known or easily accessible to persons familiar with this type of information due to their sector of activity. It also needs to have a commercial value, which can be either actual or potential due to its secret nature. And third, it must be subject of reasonable protective measures in order to preserve its secrecy. So French case law, when applying those three conditions, is not completely strict and tends to give weight on one of them more than the others, depending on the situation, saying that then if there are, for example, reasonable measures to preserve the secrecy of the information, we can consider that it has some commercial value and that is not generally known. So the evidence will tend to be on the measures taken to preserve the secrecy of the information. Then turning on the next slide. Regarding trade secret protection in artificial intelligence systems, we can see that two situations are possible. The first situation is regarding the input that would be given to the AI engines. We have seen some companies prohibiting the use of ChatGPT, for example, because they were concerned that their know-how was actually feeding the algorithm. So basically, if confidential information is transmitted to AI engines, we will not consider that appropriate measure would have been taken in order to preserve the secrecy of such information. So internal systems and practicing guides in the company will have to be followed in order to secure the secrecy of codes, for example, or information. The second aspect where trade secrets are relevant in artificial intelligence is basically how the AI engine work, on what kind of information the answers are given. And here, although we don't have any case law regarding this specific issue in French law, we can consider that the need to obtain evidence, for example, to prove infringement, will have to be articulated with the defense of trade secrets. And the right of evidence always prevails over trade secret protection. Some practical modalities can be implemented, such as confidentiality circle in case of a seizure, French saisie contrefaçon, in order to limit the access of the information, but still to be able to access the information that are needed to prove a potential infringement. Also, we could note that some justification could be raised by AI companies, such as database law, that justify the prohibition of acts of extraction or repeated use of database content. This could be an argument invoked in defense. Then on the next slide, yes, and I will hand over to Niclas.
Yes, I think we can speak both to that actually, because what we're seeing here is appropriate confidentiality measures. So the main, or the probably typically most important requirement for maintaining a trade secret and having a trade secret is ensuring that it is being kept secret and confidentiality is being maintained, and providing measures that that show that these that the trade secrets are actually maintained in that way. And these there can be both technical and legal measures. Maybe I'll start with the technical measures, such as, for example, password protection, firewalls, encryption, then need-to-know principles, so giving access only to people within your company, within the sphere of people that actually have to have a knowledge of that particular information that is subject to trade secret protection. And there can be, of course, also technical measures in that data processing is conducted in a way, and this is also maybe a technical measure that's specific to AI or helpful with regard to AI, such as processing data in an abstract manner, in implementing falsifications into data sets in order to ensure that specific information that is being confidential, or let's say if a data set in particular is confidential, that this data set as such is not being visible to too many people, or not being used in the aftermarket and so forth. So there's also technical means in that regard that can help ensure the protection of a data set specific to AI, for example.
Yes, exactly. And French case law tend to appreciate whether there can be a combination of those technical measure with legal measure. The most effective way is to have, I would say, many evidence supporting the secrecy of the information, because the mere fact of stating on a document that is confidential will not be considered sufficient by itself. So it needs to be combined with all those measures.
Yes, and in terms of specific legal measures, of course, that's probably something we all know very well as lawyers. You can sign NDAs, non-disclosure agreements, with other people who gain access. You can combine these and put similar clauses also into licensing agreements. You can create lists that actually show which data is being protected or being regarded as trade secrets. This is very important also in terms of evidencing a breach or an infringement of a trade secret afterwards. And then, of course, within your company, as already mentioned, you not only have the option of employing technical measures, but you can also put clauses into employment contracts that govern access to data and data storages, that sanction violations against the internal rules of the company. And all of this is also being taken as evidence, and speaking in particular from a position of maybe a German judge, when considering whether or not the information in question is actually being treated confidential enough to be considered a trade secret. So, Jean-Baptiste, anything to add from the French perspective? No. Then we can actually come to the next slide, and maybe an example of reverse engineering that is quite interesting. And that is also specific to the AI space. So there was a project called AIPPI at Stanford University, and this project was actually based on a different model. So we had a Metas-Llama AI model plus instruction data set from OpenAI's DaVinci 003 model. And what you can do by using also publicly available AI is, of course, you can create questions and then derive answers from that. And just by collecting a lot of these questions and answers, you can derive an instruction set or demonstrations. And with these demonstrations, you could actually train another model. So in a sense, you could, without being able to look into, of course, all of the data or all of the aspects, all of the algorithms that are subject to the AI, you can create a similar system. And this also shows the vulnerabilities of AI because, of course, simply by using it, you can gain a lot of knowledge about it. And this is also an interesting aspect to reverse engineering that's maybe atypical in other fields of technology, and that shows just how open AI is also to reverse engineering and discovering its essential elements. And if you're interested in that, you can find the model, of course, online, or the models. You can find a lot of information also about Metas Llama, and you can find the OpenAI instruction set that was used. And you can, of course, download and even use Alpaca. So this is also a very interesting solution. So if we then move on to the next slide and maybe give a brief summary. We have discussed the protection of trade secrets. We have discussed particularities of AI. We have discussed also issues such as reverse engineering vulnerabilities that are specific to trade secret protection. And that maybe can lead us to best practices, which are, of course, first identifying the trade secrets, defining it, both for you internally as a company, and then also when licensing it, for example, or giving other people access to it. We had the technical data protection measures. We're talking specifically information maintained in data. We had employee confidentiality measures. And that on the next slide will have some more related aspects. We have legal safeguards and licensing. We have monitoring and enforcement. And above all of this needs to be put together, come together in an integrated IP strategy, of course, because, and that is something that we have seen during the first and the second part of this panel, there is an overall regulatory aspect specific to AI. We will have to align with that as well. Then there is a need, of course, to protect your IP. You can use either patent law, copyright law, whatever is closest to the specific necessities of your AI solution, or also infringement issues involved can be decisive for deciding how to lay out this integrated IP strategy. And then you have maybe as a last resort, maybe as an additional measure, trade secret protection. And I think in particular in light of the new developments that AI brings with itself and the new issues arising from it, putting all of this together and thinking about how to align it is just a necessity probably for every company that is being active in this space. Yes. Jean-Baptiste, do you have any last words on that?
No, I think it's a quite complete summary of all aspects that to artificial intelligence. We are, I think, now waiting in France, just like in Germany, to address those issues. I'm especially interested in how the transparency requirements that are now raised regarding artificial intelligence will be articulated with trade secret protection.
Yes, I think that's also an issue in Germany as well, and something that we can look forward to, especially as all of the regulation interacts with IP law. We're probably going to see a lot of developments there as well. So I don't see any questions from the audience. Please, if you have any questions, feel free to ask them now. If not, we will have a short break of 30 minutes, approximately 30 minutes until 1 p.m. which will bring us to the last puzzle piece that will complete our overall webinar on AI and IP, which will be patent infringement in particular and related aspects to AI law. And we're very much looking forward to seeing all of you back then at 1 p.m. Thank you. So, hello everyone and welcome back, or welcome if you're just joining to our webinar, Young Members Webinar, AIPPI Germany. You are now joining panel 3, which is on AI infringement, particularly from a patent point of view. We've already discussed, just for a brief wrap up, the general regulatory issues and issues of copyright protection and infringement relating to AI. That was panel 2 that took place just before. And in the morning, we had a technical overview introduction into AI and aspects of patenting AI. So now we are back to a very much litigation-focused topic. And for that, we have some wonderful speakers at hand already joined us. So let me introduce them to you. We have Anahita Mousavi, who is a dual qualified attorney, both in Germany and England and Wales, and an associate in Quinn Emanuel's Stuttgart office. She joined Quinn Emanuel 3 years ago and mainly practices patent and commercial litigation with a focus on cross-border and multi-jurisdictional disputes. And she's been an AIPPI member since 2022, and since 2023, she's speaking regularly at our webinars and events. Then we have Carsten Plaga, who is a senior associate at the boutique law firm Carter Augenstein, where he started his career already as early as in 2018. And during this career, has been focusing on patent litigation, various technical fields, such as medical devices, consumer electronics, and telecommunications, so also standard essential patents, where he has gained extensive experience in his in multinational litigation in particular, and also, of course, before the UPC, just to add that. And then we have Jonas Smeets, who is a senior associate at Bird & Bird, part of its IP and patent litigation team, also in Düsseldorf, similar to Carsten, is also from Düsseldorf. And he's thriving at Bird & Bird, of course, and behind the success of several of its major cases relating to AI infringement, and also the licensing of AI portfolios. So he has gathered also extraordinary experiences in cases up to and including also before the Federal Court of Justice in Germany, and again also the UPC. So with that, we have 3 experienced litigators before us, and we're very much looking forward to your insights into AI aspects of patent litigation.
Well, thank you, Niclas, for your extraordinary introduction of the 3 of us, and we are very proud to have the opportunity to speak in front of all of you. And for us, it's basically, as litigators, maybe the task to now raise more questions in a presentation than we can answer, because most of our cases come with lots of questions in the beginning, and for us it's actually one of the major tasks to raise the correct and right questions. And with that, if we look on the first slide here, short question, yeah, perfect, thank you very much. In a globalized and digitalized world, we need to discuss the different layers of a patent infringement case that might relate to AI. So we have research and development tasks which are being made by companies, which lead to either embodiments or embodiments and patents, and certainly have different use cases. And now for my beginning of this presentation, I want to show you, or I want to learn with you with examples rather than the rules itself. Because AI learns by continuously reassessing its knowledge, forming new connections, prioritizing information based on new data it encounters. And nothing else is what we do as litigators. in the term that we have to reassess our knowledge after each and every case, because even each and every case is different. And with that being said, deep learning refers to the vast number of layers these networks can utilize. And as litigators, we want to utilize the different layers as well and want to make that as easy as it gets and bring this understanding to the courts. So while the accuracy of the results is impressive, the decision-making process remains unclear currently, not only before the court, but even to AI experts and the AI itself. So we have heard in the morning, and with that, I want to show you the next slide, that currently the number of Gen AI patents is rising tremendously. And you've seen in the beginning that there have been some key points. 2011 was one of these key points where Siri came into play of Apple. 2017, the introduction of transformer models, machine learning and deep learning was introduced for the first time. And in 2022, ChatGPT was introduced. So each of these times we have seen a tremendous increase in Gen AI patents and Gen AI scientific publications. And why do I mention that again? Because it's the companies behind that, when we now go to the next slide, that you see that we have a very strong AI market in the US and in China. And that is the litigator's realistic view on how the market currently is perceived and how the market is currently developing. Each and every case begins with the potential infringer and the potential patentee. And both of these are currently not so much European-based, although a couple of weeks ago, a case surfaced where the German supercomputer firm Partec sued NVIDIA in the UPC, seeking an 18-country patent injunction against an AI chip giant. And what was that case relating to? That was relating to the DGX product series of NVIDIA, so a server series. So we have a product, we have a patent, and we have two companies facing each other. And the realistic is here that this is currently the development in the Gen AI sector that is now partially being even more mirrored in courts over time. And currently, the truth is that the world share of published patent families in Gen AI is 70% China, 15% US, and the rest is shared among the others. But let's now go to the next slide where we see what current patents we have. The WIPO suggests 4 ways an AI might contribute to an invention. So that is AI models or algorithms as the strongest form, where an AI model is capable of doing something on its own. Then we have AI-assisted inventions, where the use of AI, potentially in a drug discovery, to select drug candidates, can help the human behind it to make the invention more fast, even better, more efficiently. We have AI-based invention, where a translation, so an AI model might even be integrated into a certain product, like a cell phone or a computer, and that helps you with something you are now facing as a task as the person behind that certain product. And in the end, we have these AI-generated invention, which is the case. We have seen Davos, and in that, if you are interested, please have a look into the artificial intelligence project that is you can find it on the internet. Just Google Davos. Very interesting case where the AI model itself generated the invention. Well, that is seen very critically. And if I, as a litigator, would get the case where the patent comes from an AI invention, I would have currently very much trouble to litigate that in court and to get an injunctive relief claim over that. But if we now look at the next slide, we see that we have various embodiments, business models, so to say, and various user models, user levels. And we need to ask ourselves in the beginning of each case, what business model do I currently look at, and what user level am I on? And we have heard already over the past couple hours that the user level may not take place in Germany The business model may not be produced in Germany, but all in all, each and every step that we see here might have been taking place on a different side of the world, might have been taking place only partially, and we need to ask ourselves, how do I attend to this certain problem? As in other areas of law, see, for example, trademark law, and also in patent law, the Federal Court of Justice has held that also given in patent claims for injunction, information, and damages, insofar as there is a risk of repetition beyond the specific infringing act, to the extent of such acts in which the characteristic of the infringing act is expressed. So we have an infringing act, and that has some characteristics. And the Federal Court of Justice in Germany asks each and every claimant, please explain to me those characteristics. Please explain to me what is behind the infringing act you want to have injunctive relief on. And only if you can explain to me in easy words your invention and your injunctive relief claim, I can grant that to you. So that is my task as a litigator, and that is your task potentially as a company and as somebody being working in AI, to bring to me the facts that I need to know. Facts, facts, and facts. And that is my red string that goes through this presentation that I want to make you aware of. You have to look into the facts first. And in a patent infringement action, the characteristic core is usually determined by the actual design of a particular product with regard to the features of the asserted patent claim, but it is also determined as to the subject matter in dispute. So it's not only the technicality, but it's also the way a certain product is distributed, handed over, produced, brought on the market. And that notion is not very often looked at too closely, because the courts might find it easy when there is a certain product. For instance, I have a computer, I have a cell phone, I know where it is produced, I know where it goes to. But in AI, this might become even more important in the future, when it is not clear which part of the process is doing on which server, which part of the process is being realized on which product. So for me as a lawyer and for you as working in that industry, it is important to look at the embodiments and the user level very, very closely, because that in the end, when you ask the right questions in the beginning, makes your case easier. So let us have a look at some of the user levels on the next slide, where we see that is currently taking place. We have heard in the beginning cases about medical devices, but also in healthcare and biotech, as well as agriculture and automotive. We have daily application areas of Gen AI patents. And these Gen AI patents relate to software applications that are being used in certain embodiments, life science products, document management systems, business solutions in general. We have heard that it is problematic to get finance services patented for AI patents. But the truth is, you have so many services around it, and which might take place on user level. Please show me one current developer who is analyzing the stock market without AI. So that is not existent. All of these people, we all are currently so deeply involved in that technology. And actually, it's a lot of fun, and it's a fast-paced area and an environment that is so exciting to be in. But we have to reassess our knowledge. That was my first slide, from day to day. And so we see that also in transportation, security, and last but not least, of course, in telecommunications. So let's have a look at each of these models one by one. So we have a business model AI. Which can these be? These can be artificial neural networks, GANs we have heard, LLMs, variational autoencoders, diffusion models, autoregressive models. And I, as a litigator, although I do not understand the technicality behind it in every aspect, I need to understand what each of these mean, what these use, what these do. Same for AI training on the next slide. The main Gen AI data types currently include image, video, speech, sound, music. So among the different Gen AI modes or the type of data input and output, most patents belong to the image video category. Image video data is particularly important for GANs. Patents involving the processing of text and speech, sound, music are key data types for LLMs. So looking to the AI input, we of course have 3D image models, chemical modules, genes, proteins, and code software. Although these have fewer patents so far, the healthcare industry is currently ramping up their patent portfolio in that regard. And we will also see certain kinds of litigation over that coming in the future. Last but not least, we have the business model AI output. Prediction, diagnosis, recommendation, images, designs. Now we are very much more on the user level, on the end stage of that introduction slide that you had seen. So that being said, we also need to look that we have an interdependence, as we can see on the next slide, between the models and the modes. And very recently, in April this year, the WIPO has released the interdependence between Gen AI models and Gen AI modes. And I think that is a very interesting figure we see here, because we need to understand what modes, like an image or a video, is used in what model. And is that case the client is presenting to me, or that I am confronted with maybe as a potential infringer, is that a realistic case? Is that typically the case in the scenario here? And if I gain understanding of what modes and what models are interdependent to each other, it makes me easier to understand later the case itself. So we can also look at that from a different angle on the next slide, when we look at the interdependence between the Gen AI models and the largest Gen AI applications. So from models to modes to applications, or from modes to models to applications. Because what I'm in the end confronted with is a business solution, is a document management system, is an industry, manufacturing, telecommunications, whatsoever. And this uses a mode, and this is featured by a model. And getting all that knowledge, if I can make it if I understand it on a certain level, and it's easier for the court to pertain that knowledge as well, I need to make it, if possible, on one page only. I need to show my facts. Where does I come from? Where does it go? And what do I want to claim from it? In Germany, in law education, we have a saying, who, what's, want, from whom. And now I also need to ask, where does it go? So you have to add this certain feature that now is more and more important. Where does it go? So let's have a look at 1, 2, 3 cases that we have had in the past. And I have already introduced the ultrasonic transducer case to you, because that is actually the case that I had litigated, and where the Federal Court of Justice asked for the notion of, please describe to me what is the characteristic behind the infringement, and what are the characteristics of the distribution line of that certain product. So while this is a very common product claim, and that has nothing to do with AI in that sense, the technology it is used for is an AI technology, because every automotive that is using autonomous driving needs ultrasonic transducers, because an autonomous vehicle uses these transducers for short-term analysis of the surrounding, whilst it uses cameras for maybe 5 to 10 to 15 meters surrounding, and laser or LiDAR technology for the long-term surrounding. So you have a product that is used in AI, and we currently see the I have introduced with the Partec v NVIDIA case, where the DGX product line of NVIDIA is at stake, which is servers primarily geared towards enhancing deep learning applications that are within the product. But oftentimes to bring to the knowledge and to the attention of the court, I need to understand the whole surrounding of a product, and I need to understand the holistic approach of the product and what does it mean, what does it bring. So another case is the communication device cases. I've spoken about communication devices. AI is used in the manufacturing process. It is very common for ports and harbors to use communication devices amongst vehicles, for instance. And if I now attack one of these vehicles, I of course also attack the AI notion behind it. And maybe my patent claim relates to a certain feature, a method within that understanding of the vehicles to each other. So I now need to explain that method, that feature, what is it doing, and how is that happening? Is that located in the source code? Maybe. Is that located on a chip? Maybe. I need to ask these questions. And once I got the answers to it, if I'm the one that having the burden of proof, and with that, you see I shift a little bit over to my colleagues Anahita and Carsten, who will talk about that in a minute. I have these devices like a detection of a moving object for scanning a fixed object. How does the no, that's fine. Go to the next slide. Thanks. If I make use of certain features of a product using AI, I need to understand the rationale behind it. And I need to understand the user that is using it, and I need to understand the producer and manufacturer that is producing it. And only if I can describe my use case, next slide, please, I can make my case in court. So I might have a foreign manufacturer, I might have a domestic manufacturer, I might have a domestic car manufacturer. So now you see, as the German guys we are, we use an example from the automotive industry. But the automotive industry in Germany in the past has produced their cars in Germany, has automotive suppliers from Germany, and has sold their cars to everybody. But the world has changed. Many of the manufacturers are no longer, of the car manufacturers are no longer even German. But we see really tremendous developments in Asia, in the US, where a lot of really high quality cars are about to come from. So currently we have a couple of companies who offer driver assistance systems. You all know Tesla, of course. But the only company that is having the SAE level 4 regulation currently in place is Daimler and BMW. So Daimler is not wrong, it's Mercedes-Benz by now, but Mercedes-Benz and BMW are the only companies allowed to drive at a certain level with their cars autonomously. So there's so much knowledge in this process. And it is for us as litigators to ask our clients about their knowledge. They have to bring it to us and we have to bring it to the courts. And only if we manage to keep the case easy, but at the same time manage to also get the critical information that is maybe complex, we have the ability to make our claim before court. So what is my key takeaway for you? And maybe let me know if you share it, and please ask questions in that regard if you have some. Divide et impera. Make your case as easy as possible. Step by step, these technologies are complex. So what is your case? What is your competitor's case? What is the characteristic invention? And what is characteristic for infringement of the invention? And now, with that being said, I gladly like to hand over to my colleagues, Carsten and Anahita. And I hope that my introduction gave you some insights of where to start with your AI infringement case if you have one. Thank you.
Thank you, Jonas, very much for throwing me the ball over the fence. As you have already touched on, there are currently numerous questions about how AI patents can be enforced in patent infringement proceedings in the future. We have not seen any decisions in patent infringement proceedings concerning AI patents. The questions where we're asking ourselves today will be answered by case law maybe in the next few years. What do I mean with the next few years? That's maybe not 10 years, but maybe 1, 2, or 3 years. I expect that the first patent infringement proceedings on AI patents and the decisions are on the horizon. What we have just seen in Jonas' part is a large number of AI patents have been filed in the recent years. This means that a large number of AI patents will be granted in the coming years. And as soon as the patent has been granted, patent infringement actions or preliminary injunction proceedings can be launched. Jonas has already told us a lot about the different business models and possible targets in such proceedings on AI patents. We therefore ask ourselves which questions could become particularly relevant in such patent infringement proceedings concerning AI patents due to the different business models and the different targets. And you can already see from the slides which issues are likely to become relevant from our point of view. It has to be said and could also have a decisive influence on the outcomes of proceedings. First of all, we have the issue that the Infringement Act will take place in different countries. What do I mean with that? If you have a protected method, parts of the methods can be proceed in different countries. This means that only part of the protected method is carried out in Germany, for example. The question therefore arises as to when a patent is infringed in Germany, even though only part of the protected method is actually realized in Germany. With this in mind, we will also consider whether the process outputs themselves can be protected. After all, this would circumvent all the problems arising from the fact that the method is only partly carried out in Germany. Another issue is that the feature products are ultimately software, and this software can be customized or configured by the customers. It may be the case that the software as it is, as it delivered, does not realize all the features of a method claim, for example, but the customer adapts the software through settings, configuration, etc. in such a way that the software then performs the protected methods for the customer. In such cases, the question then arises as to whether the company supplying or providing the software is also infringing the patent. Last but not least, there will be maybe cases where the software product fulfills only a part of the protected method or apparatus claims. This is known under the term indirect infringement, and we will go through the requirements of the indirect infringement at the end of my session. And to answer the last question of my slides, yes, there's already case law on these questions. In the recent years, we have seen a lot of case law on the subject of software patents, and this case law will also be the starting point for the new cases on AI patents. We will start with a judgment of the Regional Court Düsseldorf, dated in 2020, that's known under the German term Online-Sehtest, in English Online Vision Test or I-Test. First, we'll go through the protected methods of the patent in suit briefly. For the slide, I had shortened the claim on the protected methods somewhat. A method, so we are talking about a method of testing vision of a human subject, said method comprising the steps of calibrating, so at least one physical characteristic of a video display device, and then displaying said sequence of graphic objects with that video display device to perform a series of tests of the visual function of the human subject, then recording actions of the human subject performing in response to the display of said sequence of graphic objects. At fourth point or fourth feature, calculating from said record actions at least one aspect of the visual functioning of the subject, and as last point, calculating at least one corrective lens prescription for the human subject from said at least one of the calculated aspects. The patent therefore protects the method of testing person's vision, consisting of an eye test or vision test in the features 1, 2, 3, and the calculation of visual function and corrective lens prescriptions in the last 2 features. We will come to our next slide where we want to take a look on the facts of the case. The defendant offered a vision test on a German language website. The user's vision test is performed on the user's computer through a client-server connection with a service located in Ireland. At the end of the test, staff based in the Netherlands access the validated data, and users are sent a corrective lens prescription calculated in the Netherlands in form of a spectacle passport containing values for 3 axis and cylinder and so on. In this case, the original Court of Düsseldorf held the patent had been infringed. We will go through the key points of the decision briefly. Liability may also be possible if the last step of the method or process is not carried out in Germany. The domestic success of the invention referred to by a recent decision of the Higher Regional Court of Düsseldorf in an early decision can be seen not only in the completion of the claimed process in Germany, but also in the domestic achievement of the intended advantages of the invention. If the advantages of a patent process occur due to the process steps carried out in Germany, and if they have the effect in Germany, a domestic inventive step, and thus in liability can be affirmed even if the process is only completed abroad. This applies in particular if the last method step carried out abroad makes no relevant contribution to the advantages of the invention over the prior art. If liability is affirmed here, an economic normative consideration must be made in the second step to limit liability, as in the case in which the last process step is carried out in Germany. Domestic use can only be affirmed if the appropriate foreign act is purposefully tailored to have an effect on the domestic market. The advantages according to the invention are achieved by the steps according to features 1, 2, and 3. Can slightly go back to the first slide. And also the protect method only comes to an end with the feature 5 and calculating the corrective lens prescriptions. This step ultimately does not make any significant contribution to the objectives of the claimed teaching. The teaching of the patent in suit has the advantage to enable optical examinations to be carried out without bulky or generally immobile, expensive equipment and so on. In the contested method, the features 1 to 4 are realized domestically. This is also where the advantages of the invention are realized because the protected teaching makes the use of the lens or other equipment unnecessary in Germany. Yes, so in summary, it can be said that in its decision, the Regional Court Düsseldorf looked at the country in which the advantage of the invention are realized. In the present case, this was Germany, so that the Regional Court affirmed the act of infringement in Germany. This case law is therefore very patent owner friendly, as the advantages of the invention is generally likely to be realized in the country where the user is based. For example, if the user has advantage through this online service or the provider has advantages in this country, for example, by saving expenses. So we now come to this decision by the Regional Court of Mannheim from 2018. In this judgment, the Regional Court also had to decide on a case in which a method was carried out in which not all steps were carried out in Germany. So the subject matter of the patent ensued was a method that is based on recommendations that we are all familiar with from the internet. These are recommendations such as customers who have looked at this product or bought this product have also looked or bought this and that product. I will not go through the claim in detail as it reads a little bit too complicated to go through it quickly. The subject matter of the attack performed method also includes various recommendation categories that provide the users with information on further content of potential interest. So the case was based, so it's called music streaming, and it's Spotify in this case. So you're aware of the functions. For example, the user is provided with playlists of music tracks under the term Discover Weekly based on previous listing behaviors. Furthermore, the functioning provides a so-called This Is playlist, which refers to a specific artist or band. In connection with this playlist, the user can receive a further playlist with the title Go to the Playlist Radio. And you have also further recommendations in the user interface with the corresponding label appears. This is playlist screens and release radar and autoplay functions. The data processing steps necessary for these recommendation functions, such as obtaining playlists, analyzing the content of the playlist, creating user profiles, and calculating and sending recommendations, are not carried out in Germany or in German servers. This was based in Sweden. In Germany, the defendants only maintain servers in Frankfurt am Main that provide music content and act as in music databases. Further details on the functioning on the various recommendation functions were disputed between the parties in this case. Now we come to the decision. The regional court Mannheim has denied the patent infringement in this case. The main reason were as follows. The liability for individual acts carried out abroad is only possible in Germany if only a preliminary or intermediate product is produced abroad. But the final process steps that are decisive for the success of the invention are carried out in Germany. So that's completely different to the decision of the original court Düsseldorf. The liability is justified here by the fact that the success according to the invention is ultimately realized in Germany. And that's in this case not the case. This is because the core idea of the invention itself is realized in Sweden. It is true that the search of the virtually standardized space that gives rise to the patent method in the first place is initiated in Germany, where the recommendation also arises as intended. All other steps, which are the basis for the recommendation, creation of the user profile, creation of the virtually unified space, and so on, are realized abroad in Sweden. According to the both, liability of acts committed abroad to the domestic territory requires, in particular, in order to take account of the country of protection principle, that the acts committed in the domestic territory are of such importance for the specific protected method claim that the infringing act is ultimately to be regarded as having been committed in the domestic territory, because the success according to the invention is realized there. So what can we learn from both decisions? The case law is not uniform among the German regional courts. In any case, the regional court of Düsseldorf was much more generous in favor of the patent proprietor than the regional court of Mannheim. The advantages of the recommendations are realized by the individual user who benefits from these recommendations and can discover more new music. According to the judgment of the regional court Düsseldorf, this case should therefore also be considered as patent infringement in Germany. The recommendations are intended to simplify or improve the use of the app in Germany. So the recommendations are also based on the user's behavior in Germany. So a different court, different decisions. It has therefore not yet been conclusively clarified when a patent is infringed in Germany if part of the methods or procedures are carried out abroad in another country. For patent proprietors in particular, the question therefore arises as to whether the method product also can be protected or is protected on its own. On this question, we have already case law of the Federal Court of Justice. This judgment was handed down in September 2016 and is known under the term receptor tyrosinase 2. For me, it's nearly impossible to spell this word out in German, so I will not try to translate the word in English. We will come to the facts to the case. The claimant took the activation against the use of test results in Germany. Findings contained results of the method protected by the claimant, which was carried out by the defendant in the patent-free foreign country. The patent relates to the method for detecting a tandem duplication mutation in a nucleic acid molecule. According to the teaching of the patent, this serves as an indicator of leukemia. We come to the decision. In order for a direct process product to be covered by the protection, it must be its nature qualify as a suitable subject matter of the patent. This is only the case if it has technical proprietors that have been imparted to it by the process. Therefore, important, in the field of diagnostics, protection is only possible via a method claim, though we have all the problems I have mentioned before. And what does that mean? You have to maximize the chances of enforcement. You should care about be taken when filing the patent application to ensure that the notification of findings is also included in the claim as a last step to take into account the different case law in Germany. So now we will come to the question, does software have to realize all features already in the delivered or provided state, or is it sufficient that the user can produce a patent infringing situation? To answer this question, we will take a look into a decision of the Higher Regional Court of Düsseldorf of the year 2015, so it's nearly 10 years old, this decision. To answer this question, we will take a look into the decision. I will briefly go through the facts. The device is offered, indicated, and or supplied, which when delivered does not make use of all the features of the technical teaching protected by the patent. But the customer will naturally and certainly make a modification to the device that falls within the scope of the protection of the patent. So, and here the decision was that we have no direct infringement if the customer has to activate the protected encryption logic, that was here the case, for which a function must first be called, for which at least rudimentary IT knowledge is required. So what can we learn from this decision for AI patents? If it's easy for the customer to configure the software in a patent infringing state, then a patent infringement can be affirmed also for the company who is delivering the software. If the customer needs to change, for example, the source code, then a court would deny an infringement for the company who's delivering or providing the software. As we have heard, the indirect infringement of AI patents has some hurdles. We therefore will take a look on the requirements of indirect infringement, as if the requirements of indirect infringement are met, the court also affirm an infringement. So we will go briefly through the general requirements, the objective requirements. For this, the means must relate to an essential element of the invention. What does it mean? Yeah, it is a question of the individual case, but the means must also be objectively suitable for realizing the invention. Then we need offering or delivery must take place in Germany. So the indirect infringement has to be denied when the product is supplied abroad and the product is to be manufactured there and supplied to the domestic market. So this is a case of indirect infringement. This is what's wrong with deny. That is a case of indirect infringement. Not a case of indirect infringement is, for example, offering, etc. pp. In Germany with the purpose to produce the product abroad. We have further situations. We cannot go through all the cases, but these are two cases to give you impression how the case law is regarding the indirect infringement in Germany. Furthermore, we need to fulfill the subject requirements. The company has to need positive knowledge of the intended infringement. If the company do not know that the means will be taken to infringe the patent or for the facts to infringe the patent, the requirements, the subjective requirements are not met. What has this for implications for the AI patents? Claims should be phrased in such a way that there is a direct infringement in the case of a possible target. And this is what we have heard from Jonas. We have to take a look on the targets, on the user levels, and have to take care by the facts on where we have which business model and where we have infringement cases or where could be infringement cases. As we have to jump over the hurdle for the direct infringement at the best case. Now we will come to my last slide. What are the key takeaways from my part? Yes, a process claim under German patent law may also be infringed if part of the processes are carried out abroad, for example, in Sweden or so on. But a difference in the case law of the different regional courts we have seen in the past. The presentation of an examination result does not in itself constitute an infringement of a method claim. And a patent infringement is also possible if the customer makes a modification that first fulfills all the features of the patent claim. Yes. What is my prediction for AI patents and infringement cases? It will be decisive which part of the method are carried out in which country. And the patent claims should be written with a possible target in mind. So it's better to have not only system claims if possible in the patent claims, and mobile device claims tend to be easier to enforce than server claims. And yes, method claims on the user level seems to be the best to enforce in German patent infringement proceedings. Now you might say, Carsten, that all sounds very interesting, but don't we have much bigger issues or hurdles to prove the patent infringement? I would say it depends on the individual case, but you're right. In some cases, the main issue will be how to prove the facts giving rise to the infringement. Anahita, it's your turn.
Thank you so much, Carsten, and also thank you, Jonas. So as Carsten has already indicated, now we're gonna talk about how to evidence infringing acts. Carsten, you can go to the next slide, please. So how can a rights holder prove that such infringement is actually taking place, or the alleged infringement is actually taking place? Before we jump into the legal requirements, let's assess what sources of evidence might be available at all. For one, there's product testing and analysis. Product testing is typically a way to demonstrate a potential infringing implementation in the accused product. In the case of AI solutions, however, that might be done by the comparison of input and output data. However, AI solutions are complex and a specific output might be achieved in more than one way. We have heard about this black box issue multiple times already. Therefore, product testing might only be the starting point in the case of AI patents to prove infringement. In this context, some important questions to ask when trying to understand an AI solutions are: where and by whom is the model being trained? Is one AI model used, or are multiple used? Are external tools or other resources used? So therefore, seeing what the limitations of product testing and analysis can be when trying to figure out whether an AI solution might be infringing, additional information such as manuals, advertising material, etc., can be useful to substantiate a patent infringement. However, there has been a reduction of publicly available material about the workings or inner workings of AI models. As with the rise of AI models as revenue generators, the owners of these technologies realized that the best way to safeguard AI-related IP might be to just keep their functioning secret. But as we will see later, mechanisms that might give the rights holder access to sensitive technical information, like the source code. We can go to the next slide. The third possible way to or source of evidence might be expert reports and testimonies. So technical expert could be used to explain how the AI system functions. How Jonas has said, it is very important to be able to properly and in an easily understandable language explain what the accused technology is. So they might be helpful there. But another problem or issue in this context is that given that black box problem, the internal workings and decision-making processes are also not easily interpretable by experts, which might weaken this evidence. So given that we are in an area where it might be hard to gather facts about what exactly is happening in the AI model, when we go to the next slide, we will target the question of standard of proof and burden of proof because they will gain significant relevance when there is not that much evidence available or readily available. So let's have a quick look at the relevant standard and the burden of proof in infringement proceedings, first in Germany, then in the UPC system. It is important to note in this context that there is no specific regime in this regard for AI inventions. So in Germany, the court must possess a degree of certainty which silences any remaining doubts about the truthfulness of the facts it will rely on without necessarily ruling out any doubt entirely. So you don't necessarily need scientific certainty, but the court must be more convinced about, for example, there being an infringing act than it being doubtful about it. And also, it is important to note that in Germany, taking of evidence usually doesn't happen. It is rather typical that each party will submit together with their pleadings documentary exhibits which are treated as further pleading to substantiate the claim. Taking of evidence is only required if sufficiently substantiated facts that are relevant to the decision have been sufficiently disputed. That leads us to the question of the burden of proof. In Germany, the primary burden of proof of the claimant. So the claimant has to offer evidence, and if it fails to do so, the court will first indicate the respective party to offer evidence, and if it fails to do so, it will decide on the principle of burden of proof. So given there are potentially scarce resources to determine an infringement in the first place, this primary burden of proof might put the claimant on the back foot. However, in Germany, the claimant will meet its burden already when it has substantively alleged infringement. And then the defendant will be given a secondary burden of proof. So the claimant, for that, the claimant has to substantively allege infringement and lack access to certain pertinent information regarding the disputed embodiment, or access is only achievable under disproportionately challenging conditions, while disclosure remains feasible and reasonable for the defendant. This means for a claimant to bring a case, it might be enough to show the likely functioning of an AI model based on appropriate product testing in combination with fitting publicly available information. Then it is up to the defendant technology in the UPC system. As regards to the standard of proof in the UPC system, this in itself can be seen as a little bit of a black box at this time, because for the main proceeding, the UPCA only stipulates that the court shall evaluate evidence freely and independently. There is only further provisions about the standard of proof when looking to interim relief. So this might give some guidance on the minimum standard that has to be met. Also for the main proceedings. When in interim proceedings, the court must be satisfied with a sufficient degree of certainty that the conditions for relief are met. But given the summary nature of the proceedings, the requirements for the degree of conviction in the proceedings for interim relief are lower than in the main proceedings. So it can be said that a mere improbability might not suffice to meet the standard of proof also in the UPC system. Which takes us to the burden of proof in the UPC system. We will also keep this at a quick overview. Yeah, exactly, thank you. So with regards to the burden of proof, Rule 171.1 is quite interesting, pursuant which not only for disputed facts, but also for likely to be disputed facts, evidence has to be offered. Given the front-loaded approach of the UPC, it has to be well considered whether evidence, for example, just in form of offering to prepare an expert report, should be offered. When we look at Rule 171.2 of the Rules of Procedure, it is required that facts have to be expressly disputed for them not to be considered accepted. As to the standard that has to be met there have been two very recent first instance decisions which could give anyone in litigation before the UPC some guidance. The local division Mannheim has decided that a blanket denial is not sufficient to meet one's burden of proof, in particular when nothing was said to contradict the claimant's submission. So there we talked about in the beginning about the claimant being on the back foot maybe in infringement proceedings regarding AI patents, but if the one chance there for the claimant is if the defendant does not or just resorts to a blanket denial because they don't want to disclose the information they use. Then the local division Paris, according to the local division Paris, also a screenshot can be considered as evidence. And if the evidence introduced is not challenged, it cannot be considered to lack probative value. Exactly, yeah. But the UPCA also knows a rule with regards to the reversal of burden of proof. This might become also increasingly relevant in with regards to the infringement of AI patents. But at this time, there is no UPC case law that might give some guidance on how the courts will apply this decision. And in the interest of time, we will now move on and look at the preservation of evidence and the inspection under German law. Some might know or provisions similar to this as a saisie. So let's look at the mechanisms that enable the rights holder to access evidence that might enable it to plead its infringement case. In both the German as well as the UPC system, it is available to a rights holder even before proceedings begin, and a preliminary injunction is possible without the hearing of the opponent prior to that. However, in both systems, the court has to take measures to ensure the protection of confidential information. In Germany, specifically, a procedure has been developed by the Higher Regional Court Düsseldorf, which is now established under the name Düsseldorfer Praxis, to allow the rights holder to enforce its procedural rights while protecting the interest of the opposing party. And this is done through a combination of, could we go back again, please? Thank you. So this is achieved through a combination of independent evidence proceedings and an interim acquiescence order based on the substantive right to production. So what usually happens is that a court-appointed person will inspect the allegedly infringing product and will write a report. This report will be redacted to the extent necessary. And now we can look at the case law in this regard. Yes, because there was a decision of the Higher Regional Court Düsseldorf in 2021, and the court there ruled that the court which is authorized to order confidentiality measures under Section 140C may adjust or revoke these if necessary. Details of expert opinions in the inspection proceedings that are outside of the scope of the evidence warrant are generally not disclosed. But now there comes the crux. This does not necessarily apply to aspects that a party has itself made subject of the inspection procedure through its submission. Even if the facts are presented, presented by the respondent are not directly related to the subject of the inspection. And also in this direction, if you go to the next slide, there has been a decision of the Federal Court of Justice very recently in 2023 called aesthetical treatment. And there the German Federal Court of Justice has decided or given guidance regarding the challengeability of orders pursuant Section 140C Patent Act and the scope of the German Trade Secrets Act. So basically how these provisions work together. As we pointed out, the respondent, of course, has a big interest to keep the technical details of the methods or the AI products they use a secret. So this was very important. And in aesthetical treatment, again, the Federal Court of Justice stated that if the respondent wants to prevent the expert opinion to be fully disclosed to the rights holder due to the protection of trade or private secrets, it must demonstrate the factual grounds for this. And any necessary protective measure should be determined based on a comprehensive assessment of all affected interests. So as we see, there are definitely some ways in which the civil procedure rules try to make it easier, or make it also easier for owners or rights holders of AI patents to gain the necessary evidence to plead their case. So let's look at the UPC system. As you will know, thank you. As you will notice, the requirements of the preservation and inspection of evidence in the UPC system sound quite similar to what we have talked about regarding Section 140C German Patent Act. So therefore, let's jump right into two recent decisions regarding these procedural mechanisms. In its decision of July 2024, the Court of Appeal clarified that a request for an inspection automatically implies a request to be given access to the result of that inspection. as the purpose of ordering an inspection is to enable the applicant to decide on the basis of the results whether or not to initiate substantive proceedings. This is already the aim of the applicant's request under Article 60, Section 3 UPCA in conjunction with Rule 199.1 UPC Rules of Procedures. However, the results of the inspection may only be disclosed to the applicant subject to the protection of confidential information of the respondent. The following steps can therefore be seen. The following steps for this purpose arise from the order of the UPC Court of Appeal and the decision of the local division Mannheim, which I have noted at the bottom of the slide. So the first step would be that the report opinion shall be forwarded to the defendant upon receipt by the court, with the request that the respondent should state within a period to be determined by the court whether it contains secret information that may not be made available to the applicant. If the court, after considering the response of the defendant, denies interest in confidentiality, it releases the report or opinion in its entirety to the applicant for further distribution. If the court's view the defendant may have an interest in confidentiality, it forwards the report or opinion to the applicant's legal representative for comment, with the provision that the report or opinion may not be handed over to the applicant for the time being. If the legal representative of the applicant indicates that he will only be able to comment on the classified nature of the information contained in the report or opinion after consulting with a natural person from the applicant, he shall name that person. The respondent shall be given opportunity to comment on this. Depending on the circumstances of the case, the group of authorized recipients shall be expanded accordingly for the sole purpose of commenting on the confidentiality requirement. The fourth step pursuant these two decisions is that the court shall decide on the confidentiality requirement after further statement by the respondent on the applicant's statement, and taking into account the interests of both parties. And the last step will be if a third party not involved in the proceedings applies for access to the files of the inspection procedure, Rule 262.326 of the Rules of Procedures shall apply mutatis mutandis to the extent that the files contain information which the court has classified as secret. So with that, we have finished our overview of the mechanisms of preservation and of evidence and inspection. And there are, of course, other ways in which the claimant might gain access to information, which are the usual production of documents. In Germany, this is based on Section 142, German Civil Procedure Code. And under the UPC, this is based on Article 5967 UPCA in conjunction with Rule 190 and 191 Rules of Procedure. We would have to go to the next slide, please. Yes, exactly. And also there have been two decisions with regards to the production of documents, but also in the interest of time, I would politely refer you to my slides and would move on to the last point to wrap this webinar up. This is the source code as evidence. Of course, and rightly so, the source code has gained a lot of buzz in respect to AI patent infringement proceedings. So let's have a look at the source code as evidence, and first its value as evidence. So what is the source code? Most people might know this, but as a short recap, the source code is the human-readable programming code, which includes a set of instructions that defines how a computer program or as AI system behaves. So this might be useful if the patent claims, for example, claim a specific method. So then analyzing the source code may help to determine whether the accused technology uses similar code that embodies the patented innovations. But there are also limitations to what the source code might tell us. As briefly touched on earlier, AI systems, specifically those based on machine learning or deep learning, may involve nonlinear processes that are difficult to trace directly from the source code. For example, the learned model parameters, for example, weights and biases, are not explicitly shown in the source code, but are learned by the neural network through training. Also, some patents may be written in a way that the infringement relies on broader conceptual features or outcomes rather than technical specifics that can be easily confirmed in the source code. So these limitations have to be kept in mind when determining the right means to evidence an alleged infringement. So let's look at how the source code is protected. Given the function of a source code, it is definitely for the owner of an AI application system or model, a sensitive piece of information which they would not likely want to make public. But that does not necessarily mean that it is a trade secret. For it to be qualified as a trade secret under the EU Trade Secrets Directive, it has to be not generally known or be easily accessible to people who typically deal with the type of information in question. Its commercial value has to arise from it being a secret, and the holder of the trade secret has to have taken reasonable measures to protect the confidentiality of the information. Regarding the last point, encryption techniques to safeguard the source code might be able to suffice as a reasonable measure. Furthermore, also the EU AI Act implies that the source code is at least a confidential business information that shall be protected by anyone involved in the application of the AI Act. However, the Trade Secrets Directive provides an exception for the protection of the trade secret, which is for the purpose of protecting a legitimate interest recognized by union or national law. Such a legitimate interest can be, for example, the interest of a rights holder to ensure its patent rights are not infringed. So there we have a full circle moment, so to say. And then we will arrive at our last slide. That is the methods of collection when wanting to use source code as evidence. We have already discussed the legal mechanisms with which to access the source code in the UPC system in Germany, which are, again, to recap, Section 140C, German Patent Act, and Section 142, German Civil Procedure Code. And in the UPC, it's mainly Article 60 UPCA in conjunction with Rule 192 to 198 Rules of Procedure, and Article 5967 UPCA in conjunction with Rules 190 and 191 UPC Rules of Procedure. So the question remains, however, whether a rights holder might take matters in its own hands and try to reverse engineer the source code. There are some practical and some legal limitations to that. A practical limitation might be that decompiling code is not easily possible. And also, given the often talked about non-linearity of AI algorithms, the mere analysis of input and output might not suffice. And then the legal limitations are, when we look at the Trade Secrets Directive, Article 4.2, the acquisition of a trade secret without consent is unlawful if it involves unauthorized access, copying, or appropriation of the trade secret without or any actions that violate honest commercial practices. That might be seen as given if the source code is encrypted and deliberate measures are taken to basically solve that encryption or to crack that encryption. Also, when we look to Germany, there we have Section 202A German Criminal Code, pursuant which anyone who unlawfully gains access to data that is specifically protected against unauthorized access by overcoming security measures commits a criminal offense. And this, again, if the source code is encrypted, one might want to argue that this will be given. So that is, now we have to reach the end of how infringing acts can be evidenced. And thank you for your attention. And I give back to Niclas.
Thank you so much, Anahita, Carsten, Jonas. What an interesting topic. So much going on. We're still open for audience questions. If there are any, please just use the chat or the Q&A and we'll answer them. In the meantime, maybe let's have one big question for all of you, because I think that is also a good place to end the overall webinar. And that would be, do you think that AI itself will change infringement proceedings? And if so, where are we seeing, or where are we likely to see the biggest changes in that regard? Maybe each of you can say a sentence or so, and we'll just start reverse with Anahita.
Okay. Yes, I can imagine that, but I think especially when it comes to what we talked about, evidencing an infringement, it can play a role because you could use AI to understand the potentially infringing product. But I think, as we have seen also now with large language models, which sometimes do not produce necessarily reliable results or that have to be double checked. I'm not sure how close we are to really being able to rely on AI produced information in proceedings. But that will definitely be interesting, and I expect that this will sooner or later happen.
So my point of view is AI will not change the rule or our procedural aspects of the cases, but AI will change the preparation of infringement actions. What do we mean with that? AI is probably at the moment, it's possible to write parts of an infringement action with AI at the moment already. And AI will change the revocation actions and the nullity actions before the national courts, because it's easier to find prior art with AI already at the moment. And this will swift the proceedings, maybe that the key part of the proceedings is maybe more on the revocation or nullity side, and because the patents will have more problems to be valid in the future.
I just follow up on that, because I think one thing AI will definitely change. What is the definition of the person skilled in the art? That is a very valid point, because it will be much easier to assess a certain state of art at a certain point in time with the means AI gives us, because I can, in the blink of an eye, I can assess basically the global patent portfolio for a certain technology at a certain point in time. So that will change the understanding of the person skilled in the art, and to my belief, the courts have to take up on that, and the courts have to be careful that they also are capable and able of using those means, the clients and the law firms use, because only then they can validly assess the outcome that was made by that very same user. We need to be careful that On the other hand, it's of course also our task to question the results of the opposing side. But I think in prior art searches that will change. It will change as to the search of infringement. And I think the question arises, Anahita, you said no, it will certainly not change immediately the evaluation of evidence and the outcome. But at some point in time, that also might change to a certain amount. And the person skilled in the art is, to my assessment, the first aspect where this comes into play.
Wonderful. Well, that gives a very clear outlook into the future. So we have a lot of changes coming towards us with AI and patent infringement as well. And that also brings us to the conclusion of the webinar. So thank you again, Anahita, Carsten, Jonas, for your great presentation. And thank you everyone for listening in. Before everyone drops off, maybe we'll have another look at our final slide, which is of course an outlook onto the midterm meeting in Zagreb in February. So everyone, please feel free to join. There's a special rate for young members, and we look forward to seeing you there as well. And so long, thank you so much for attending.